May I please?
Yes.
With consent of the other side, Your Lordship, I beg to mention item number 46, Your Lordship.
46.
46. First of all, Your Lordship, I have some difficulty today, Your Lordship. So matter may be taken up on 27th of February, Your Lordship. And secondly, Your Lordship, it should have been come in orders column, Your Lordship, since there is a IA for bail, Your Lordship, in the pending criminal appeal. It has probably been wrongly listed in the hearing column.
The TCR has come.
Yes, Your Lordship.
Maybe we can take it up at
Lordship.
your convenience.
Lordship.
Once a bail, then a decision.
Lordship. On 27th, Your
On
Lordship.
27th,
Lordship.
at the request of Mr. S. Bhattakur, Learned Counsel appearing for the petitioner, list the matter again on 27th of
February, Your Lordship.
February.
Yeah.
Okay.
Deeply obliged.
May it please,
Yes.
Lordship, I beg to mention item number 16, my lord.
Hmm.
I have taken consent from the learned counsel for the amicus, my lord.
Hmm.
My lord, matter may be taken up after a week, my lord.
Okay. At the request of the Learned Counsel appearing for the petitioner, list the matter after list the matter on date ta দিব লাগিব না? When do you want it?
Lordship, as per lordship.
Choose a date.
Yes, my lord.
Choose a date.
My lord, 25th or 26th as per lordship.
25th.
My lord, the interim may be continued.
The interim continues.
Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 1. Is
One.
wrongly listed in the motion column, Lordship.
Acha.
On earlier occasion, CD was called for.
Huh.
Kindly take this matter
Mr. Goswami.
bail hearing.
Mr. Goswami, CD was called for. Item 1. Okay. Learned Counsel for the petitioner has submitted that the matter has been wrongly listed in the motion column
Kindly take
The-
this matter first of bail hearing.
on the 1st of
Bail hearing.
Today's list on the first of February, he is paying for that.
My senior.
Today.
Yes, Lordship, today.
today. Can you check whether the case diary is there? If it is there, not as the first, not as the first matter, he will check if the case diary is there, then we'll take it up. Huh? It will be mattibo. এই গোস্বামী সাহেবে কৈ দিলে আপুনি তেতিয়া মাতি দিব after some time. Yes. Yes.
I beg to mention item number 20, my lord.
2020.
20, my lord. Can
Yes.
it be taken on Wednesday, my lord, 18, my lord? We'll file additional affidavit in this matter, my lord.
Counsel has submitted that he would that the petitioner will be filing an affidavit. Huh? Charge sheet has been
Hello, my lord.
an additional affidavit will be submitted.
We'll file
Learned DPP has submitted that the charge sheet has been submitted. List the matter again on 18th.
18th, my lord, kindly.
18th. 18th of February, huh?
And another matter, my lord, item number 32, my lord. They're not in
32.
interim, my lord. Can it
Huh?
be after a week, my lord? 32, 32.
At the request of the Learned Counsel for the petitioner, list the matter.
After a week, my lord. They are not in interim also.
Give us a date.
My lord, can it be on
18th, huh?
9, 20,
20th.
20th? my lord.
We have received the case in the city.
My lord.
Case diary is received.
They're not in interim, my lord. Can it be on 20th, my lord?
20th of February. Learned APP shall retain the case diary received.
Deeply obliged.
May I please,
Yes.
Lordship, with the consent of the other side, I beg to mention item number 34.
Hmm.
Lordship, in this matter, we have not received the CD, Lordship.
The CD in the case has not been received. List the matter again on GST. Tell us.
27, Lordship.
27th of
CD, yeah?
February.
34.
GST is 34.
34, yeah. 34, 34 GST.
34 to GST.
GST matter.
Interim order, there is interim
The interim order passed earlier continues.
Much of it.
Not
Yes.
Item number 11, my lord,
Hmm.
the petitioner filed on additional affidavit lordship, that may be called forward. Okay.
Yes.
Lordship, item number 22,
Hmm.
can it be on 19th of this?
19th. At the request of the Learned Counsel for the petition, list the matter again on the 19th of February 2026.
May it please, your lordship. Item number 41, your lordship.
Hmm.
Your lordship, the conducting counsel is out of station. If
There is a office note. The conducting counsel in this matter has been stated to be out of station. List this matter again on
26th.
26th of February 2026.
For addition, item 2,
Interim to be considered today, yes.
Lordship, we file our affidavit.
Huh? What is the interim you are praying for?
To stay the impugned judgment and order, my lord. The issue here is that, my lord, the learned court pass an order to the husband of the petitioner
Huh?
to pay an amount of rupees to the extent of rupees 9,000.
Hmm.
So accordingly, I have argued the matter before your lordship.
Mm.
The grounds shown by the learned trial court has majorly failed the apex court judgment where the honorable apex court Rajnesh versus Neha Mylord is awarded. Where that judgment, the court has clearly stated that without going to the income of the petitioner, the learned trial court cannot give any judgment or pass the maintenance allowance to the husband. So first ground.
None of the parties had filed that particular.
My lord, I have already filed, during the course of the trial, we have filed our affidavit and assets and liabilities, all these
Ah.
things. So the question here is that, my lord,
What about the lady? Did she file?
Yes, Lordship. I have also annexed in my affidavit, Lordship. Assets and
It
liabilities.
was filed before the trial court.
Yes, Lordship. After
Yes.
appreciating all the.
we have both the
materials-
file, but the question here is that the income, the whether the husband of the petitioner was liable to pay to the extent of amount of rupees 9,000, my lord. So we have annexed two documents. Their two child studied in a private schools and as well as she earned rupees 2,000, my lord. Already that in regarding this aspect, I have already stated these things, ma'am. So she has already admitted she has earned rupees 2,000, and now the grounds that her child studies in a private English medium institutional school, my lord, that was not a ground, because, my lord, 125 of the CRPC under subsection 4, where
That is whether she gets it or not. What about the child, whether he gets
Yes.
it or not when she's
But-
studying?
even when the wife, legally married wife, and her children will awarded to the maintenance, there is no dispute on that point. Now the question here is that whether the wife, without any sufficient cause for that,
Yes, why 9,000 to you?
Lordship, I have two minor children who are studying.
Who are being provided for by the petitioner for 2,000 each, 4,000 goes there. Not 9,000 to you. Why?
Not 9,000, Lordship, 5,000 for
wife.
wife and 2,000
and
each for.
2,000.
Why 5,000 for you?
Lordship, I have to see upon my children's also, Lordship. and
That
because
is provided for 2,000 each.
Tuition fees,
That is being provided for by giving 2,000 each.
yes.
Is it not?
She is also unwell, Lordship, that is the reason.
Huh?
She is also unwell.
What does she do?
needs- Lordship,
What does she do?
no, she doesn't do anything.
Where is your asset and liability?
Lordship, I have annexed in a page number. It starts from 92 page number, Lordship. And in my readings also, I have mentioned in point number 9, Lordship. That earlier I used to receive.
When did you file it?
On 11. 13, I think it was listed on 13, Lordship. 13. And below lower court, Lordship rightly appreciated the evidence material.
Where is it in the evidence part? Where is it in your petition? His affidavit is not on record. Have you annexed her
No.
asset and liabilities? No.
My big question here is that the assets and liabilities, both the parties are submitted.
Huh?
Now the question here is that the petitioner income and rupees.
That is what we wanted to see. That document is not before us. You have not given it with your petition that this is what she had given.
Oh, my lord, I have already annexed my
Her,
income.
her.
Our income was in the record, my lord.
Which record?
It
Record
is
আহিছে নেকি?
trial court record, my lord.
আহিছে নেকি? Trial court record আহিছে নেকি?
Possibly it has been forwarded already.
Just a minute. You want to say that she has enough income
No.
and she does not require 5,000.
My lord, my humble prayer before your lordship, already when the consideration was the amount of maintenance allowance. The earlier predecessors of the judge has awarded rupees 3,000 to me as a interim allowance.
Hmm.
Now the court has a finding in the said impugned judgment and order that he has failed to pay rupees 3,000. But instead of it, he has paid the money to his wife by way of Google Pay, my lord, and I have annexed all these documents.
That is interim.
Now
lordship.
this is the,
That was interim.
So all the interim has already been paid.
yes, as per
Hmm.
interim I have paid. Now my difficulty is that, my lord, now she leaves and deserted to me, and without showing any sufficient ground, that on the ground that her two minor children was studying in a private college, and therefore she claimed to the extent of rupees 9,000. Whether it is a grounds for to payment of 9,000 when his income is as a driver of a person, my lord, how can he pay?
Also, let my affidavit be on record if
That
it is.
that
not
part
done.
was also be considered, no doubt. As a husband, I am bound to pay the maintenance allowance. But the amount to the extent of rupees 9,000.
For the child, we are not touching for now.
My lord. So
For
my
the wife, you continue to pay 3,000.
3,000, my lord.
Lordship,
We'll remand the matter back
Yes, my lord. Remand the matter
and let her
to fresh consideration.
let her consider afresh. The
Yeah.
family court will consider it
Lordship, what-
afresh by taking into account your asset and liability, his assets and liabilities, and thereafter say what you have to pay,
Yes.
what he has to pay.
but Lordship, earlier, after considering the record materials.
No, that is what we are not finding.
The trial court has passed this order, Lordship.
Show us in which part your assets or liabilities or your illness has been considered. Show us that paragraph.
Illness has not been considered yet, but.
What
as
has
of
been
now-
considered?
Lordship, I have also mentioned.
So
in my-
far as the income, your income
And-
and his income has
and as
been,
far as
please,
yes,
so far as his income and your income has been evaluated,
yes.
which part of the judgment? Kindly show us that. He produced a salary certificate. The court is not trusting that. Page para 13.
No, also,
What about you?
I have mentioned in my assets and liabilities that
Kindly show us from the judgment that it was evaluated. We are not saying that you have not done it. What we are saying is,
yes, yes.
if the court has not evaluated it, we will ask the court to evaluate it,
Yes.
give reasons,
Us
and then say whatever you are entitled to. It may be back to 5,000, we do not know. It may become 10,000, we do not know. It may become 2,000, we do not know.
Yes, ma'am.
Lordship,
But that evaluation has to be done by the court, the trial court, is it not?
yes, Lordship.
Show us from the judgment if the evaluation has been done. We will not interfere if the evaluation has been done. To bring a quietus to the matter, it will go back after 2 years or it will go back today. When we do not find an evaluation, we'll have to bring it back to the interim. Is it not?
Yes, Lordship.
Then you'll keep getting interim for the next 2 years.
Okay, Lordship. that
Then
is-
they will come and say after a week, council not here, this not there, interim continues.
Exactly, ma'am.
Yes, Lordship. Okay.
Huh?
Okay, Lordship. Let it be remanded.
We'll keep it at 3,000. We will keep it at 3,000. Remand the matter back.
Yes, ma'am.
We are not touching the
Yes.
children part.
Yes.
2 goes,
Yes, ma'am.
she gets 3. It goes back. Let the court reconsider it on the basis of the evidence already on record.
Yes, ma'am.
Evaluate the requirement of paying you 5,000. Say why 5,000 and give it to you.
Exactly.
That'll do.
Yes, but regarding children, both the children's two.
2 each will remain. That we
Yes.
are not touching.
Yes, Lordship.
Because the children part has to be evaluated has been evaluated by the court.
Yes.
They are studying in a school, whatever is required, we will not go into them. With our minors, we are not touching.
Yes.
Huh?
Obliged.
Heard Mr. So-and-so on a council paying for the petitioner also. But your affidavit is not on record. Heৰি কৰকচোন, affidavit file কৰা বুলি কৈছে.
Yes, Lordship. My affidavit is not in record, I think.
You give the filing number, we'll call for it.
Yes, Lordship.
We'll take it up at 2 with the affidavit. Okay?
Deeply obliged, ma'am.
You give the filing number.
Yes, Lordship. Yes.
We'll call for it.
Okay.
Eto at 2. Teo headphone দিব না? WS খন লগত দি দিও. At 2 dispose, huh? মাতি দিয়ক।
Supplementary list, motion AB, item 47.
Right.
Yes, sir.
My lord, this is my lord PRS bill application
Hmm.
and lordship will find my lord FIR at page 12. Now, my lord, the petitioner before lordship is the president and secretary.
Just a minute. Not understood. What does it say?
Now, Barnacuda lordship will find at page 14.
You are who?
We are the my lord president and secretary.
Which is the page number 20? Which are you?
Yes. Page number 20, my lord, serial number 1 and my lord serial number
Hmm.
3.
Yes.
Now, lordship kindly see the my lord, suit in which my lord, the petitioners degree the suit. Lordship will find judgment at page 40.
Hmm.
Page 40 is the my lord, suit. My lord, file by
Hmm.
lordship kindly see on my lord, serial number 9. Lordship will find Sun Kumar Medi.
Ah.
He is one of the my lord, informant in the present case.
Hmm.
Now, in that suit, my lord, degree is my lord, awarded in favor of the petitioner. That is the predecessors of the petitioner's my lord, office bearer. Lordship will find at page 52. Operative
ठीक है.
part.
So, whether you are the president or not is the issue. Predecessor, how does it come into play?
Now, the my lord, NG is the same.
Huh?
We are the now office bearers.
Huh?
Now, earlier
But the
it was-
allegation is forgery.
allegation is forgery.
Then,
In the year 2019,
huh?
we are not there. Now, we came in the year 2000.
Which document has been forged?
My lord,
What has been forged?
that is the my lord, content in the my lord, affair.
What is forged? Why don't you tell us that?
Yes. Now, we are the president and secretary. My lord, they claim that they are the president and secretary.
No, they are saying that this Rajo Sakra was Sakra Bikhoya was not there.
That's fine, but the my lord, lordship kindly see the letter pad, which is our society has been used by them.
For that you go for a suit that we don't worry. Yes, sir. Forgery. What to do?
The presence of the case, you have to, whether your involvement is there or not, after presence of the case, you should signify it. Otherwise, it's
When?
very difficult to ascertain.
When? Nelly.
Nelly.
Lordship, then 27th,
Call for the case diary, 27th.
But till then, some protocol, because since notice has been issued to us,
Ah, yes.
notice has been issued, we will cooperate with the executive agency.
In the interim? Appear on or before when? 19th.
Right.
Appear on or before, petitioners will appear on or before 19th before the concerned IO in the event of the arrest, released on bail, bond of rupees 10,000, subject to the satisfaction of the IO.
Two petitioners, my lord, president
Both.
and secretary,
Both
developers.
petitioners, huh?
Item 4.
Yes.
Lordship, this application is for challenging one impugned order where Jimma of a vehicle and 600 bags of rice was rejected. Lordship will find the rejection order at page 25, Lordship.
Page 20.
25 of the petition.
Hmm.
Lordship, the third paragraph from the bottom, Lordship. The IO in his report has also stated that a prayer for confiscation of the seized vehicle and the bags of rice has already been submitted to the district commissioner, and hence as prayed not to release the same until confiscation report order has been received from the concerned authority. And under this ground, Lordship, the Jimma prayer of the truck and the 600 bags of rice was rejected at that stage, Lordship. Now, Lordship may kindly turn to page 33, Lordship. From 33 onwards,
You are paying for custody of what?
of
A
the
Zimma of what?
vehicle and the 600 bags of rice. Because Lordship, those
Why were they taken in, why were they seized?
Lordship, Lordship may kindly see the FIR. It was suspected to be stolen rice, Lordship.
No FIR of any of any theft.
No, Lordship. Lordship,
Where is the FIR?
FIR is at page 11.
Yes, Mr. Busher.
My lord, in this matter, my lord, we receive a, my lord, report from the IO, my lord,
Ah.
along with the CD, my lord.
Ah.
There, my lord, it is stated that, my lord, that is the, my lord, that is the sales, my lord, items are not, my lord, confiscated. So otherwise, my lord, it will be damaged, my lord. That is in the
Huh?
IO report. My lord, that is the rice bags
Ah.
were there, my
Ah.
lord. So that way, my lord.
Can the police maintain 600 kilos of rice
Yes,
till the trial time?
Yes, my lord. So because of that,
They
my
will
lord,
retain it and they will,
no, my lord,
cannot be.
Cannot be, my lord.
Then,
So that may be given, my lord. That is in the report, my lord.
and the truck also, it's a registered vehicle.
My lord, my lord,
Keeping it inside the state police station, how is it going to help?
my lord.
You have all the details.
Yes, my lord.
Huh?
So FCI report is there, Lordship. That
FCI.
Yes, Lordship, at page 43, Lordship. Already stated in the last paragraph, Lordship. 43, last paragraph. Additionally, it may be informed that there have been no reported incidents of pilferage, theft, or missing of FCI
What
stock.
is FRK?
Whether the seized rice were FRK rice or not, yes.
Has been lying, it has also reported that the seized vehicle has been lying in the premises of the police station in open space and is likely to suffer damage. The rice is also perishable in nature. The learned counsel for the petitioner has drawn our attention to the report given by the FCI, which says that there are no reported incidents of pilferage, theft, or missing of FCI stock in the depot under the FCI DO Gauhati during the period in question. The investigation till now has not revealed any complaints made to the police authorities regarding theft of the 600 kilos of rice involved in this incident. Full stop. In view of the above, this court deems it fit to allow the petitioner to take Zimma of the vehicle bearing registration number A01PC5964 as well as the 600 bags of rice which is involved in the present matter by giving such surety Huh?
Executing bond, my lord, as.
By giving such COT and executing such bonds
Bond,
as may be required by the,
my lord, that is the, my lord.
to the satisfaction of whom?
My lord, that is the chief judicial magistrate. my
Of the Chief Judicial Magistrate,
lord. Tata, sir.
Kamrup
Kamrup.
Metro, full stop. Criminal revision disposed of. Anything more we need to say, no?
No, my lord, that is my lord, because of settled position of Sundar Bhai Ambela Desai.
You go and give your sureties and bonds.
Much, much obliged, Lordship.
Yes.
My lord, against the order of the family court, my lord. Lordship, agreed by the quantum of maintenance, my lord.
Hmm.
Quantum of maintenance, page number 53, order part. 4,000 per month to the first party. That means wife, and 3,000 per month each to her two minor sons.
Hmm.
All total 10,000.
Hmm.
And her pleaded case is that the husband is an employee of a company and earning 30,000 of rupees. And there is no proof that I'm an employee under a company. I'm a daily wage labor. My assets and liabilities and oath, I have stated that my income is 3,000 to 4,000.
Hmm.
But only on the pleadings, there is no proof that I am an employee. The court, learned court below, on that statement, presume that I am a company employee, employee of a company, and I have a 30,000 rupees earning per month. On that basis, the impugned order was passed, my lord.
Lordship, the Indian order passed on 30 August 2025.
How old are the sons?
One is 11 years, one is 8.
Hmm.
School going. Lordship, impugned order 30 August 2025. Till that, no installment is paid, Lordship. Balance amount of 90,000
Now, but as of
And,
today, 90,000 is pending.
pending, and the NBW issue against the petitioner
Okay.
in the LCR is.
That
Lordship.
will see by the execution court, my lord.
Huh?
Execution court, that is.
No. You are approaching us for an interim order, is it not?
Lordship,
And then for a decision on the matter, is it not?
lordship.
Till the time the interim comes, you are supposed to pay, is it not?
They would-
When did you file it?
Lordship, immediately after, my lord.
When did you file it?
I have filed it, my lord. November, my lord.
What was the, any interim already allowed?
No, the consideration for interim, lordship, on presence of
Earlier.
earlier.
In the trial court, any interim was allowed? What was the interim amount? Huh?
No interim, my lord. Case was filed on 24, my lord, 2024, and judgment was pronounced on 30th of August 2025, my lord.
Date of filing, Lordship, the
Date of filing, as
Date
per
of
order,
filing the
August 2007.
amount, Lordship.
Hmm. So you are liable to pay. What is your date of filing?
Lordship, my petition or lower court's petition?
Wife's petitioner,
Lower court.
date of filing.
30th of April 2024.
30 April, Lordship.
Yes, what are you going to pay in the interim?
Lordship,
Pay some amount in the interim, come back after a week by paying the interim. Deposit some interim amount, we'll consider your interim stay.
90,000 area amount. Lordship.
Out of 90, what would you pay?
And the litigation fees,
Huh?
and 2,000 litigation fees.
That's okay. 2,000 litigation is fine. Yes. You have to pay some amount that you agree to. Tell us that this is the amount I'm agreeing to.
instruction, because I have no.
Find your instruction, come back at 2. Come back at 2. What is the interim amount you are going to deposit?
Next week, Lordship.
And we'll consider. Yes,
Next week, Lordship.
it is not 10,000 a month. It is not 10,000 a month.
Yes, yes, Lordship.
3 each and 4 to the wife.
4.
10,000 a month. You have some arrears pending.
Yes, that means
90,000.
arising out of my impugn order.
Yes, 90,000, 9 months till now. And it was from the date of filing. So that was in April 2024. Is it not? Or May?
April.
So quite some huge amount of arrears now pending. Tell us what you are going to pay.
Any other day, my lord.
What is that area? Tell us what is the amount you are going to pay.
Take instruction.
Have your instructions when?
Friday. Tomorrow.
Huh? Tomorrow is too early. We'll have to be earlier than that. At 2 or Friday?
Because I have to communicate with
Friday.
Friday.
At the request of the learned counsel for the petitioner who wants to have instructions on the arrear which is accrued after passing of the judgment. List this matter again on Friday. What is Friday? 20 February 2026. Okay.
Obliged.
Come back.
Item 5.
Similar matter, my lord. Arrears has been pending, my lord. Only 4,000 per month.
Why waste your breath when none is there?
Same tactics of.
None appears for the petitioner on call list again on 23rd. Next Monday, 23rd.
My lord, in earlier item number
23rd, my lord, I have a matter in.
24th
24th.
of February. Yes.
my lord, in earlier matter, my lord, in item number 4, my lord, one, my lord, line may be there, my lord. That is the, my lord, that the report may be kept as a part of the record, my lord. I have, my lord, submitted, my lord.
That Zimma case you dispose calling that disposed matter na. The report, the copy of the report submitted by the learned APP is kept
My lord. Already I have.
on
submitted.
record. It's
Obliged.
kept on record.
Maybe the Lordship, in this case, Lordship, my track has been seized in 8 years back, Lordship. 8 years back, my track has been seized.
Your
Track,
track,
Lordship. And ultimately, Lordship, whatever confiscating procedure has been drawn, and that order has been silenced, that also goes against me. But now, Lordship, I am coming that in the year 2022, Lordship, it's very much sure that the state government has been decided to withdraw the petty offences.
Yes, this order dated 16/12/05. Have you seen 2025? We had requested this court.
My lord,
Special PP Forest Department.
Forest
Yes,
will
get
appear, my lord, in this matter.
Forest Special.
I already informed Lordship, but he is not responsive.
He is not responsible. No, there are somewhere around 24 more rooms where he may need to respond. Is it not? Then scroll the deduction. PP Forest. Item number 22.
Item 8.
Well, this case is the outcome of a civil dispute. Some process is going on, Malad, for amicably settle the matter, Malad, outside the court. So should we take up after 4 weeks, Malad, in the meantime, Malad, if possible, Malad, will come up with.
After 4 weeks, he wants a settlement.
My lord, time may be kindly fixed, my lord, because that if they.
We'll have a fixed date.
Yes,
To your choice.
my lord.
To your choice. Give us a choice. It is your choice. He has made a proposal.
Because they have to forget the place. That is.
He has made a proposal
Man.
and we are giving the choice to you. Choose your date.
Let it be within 2 weeks. 2 weeks.
Give us a date. Mr. Isaac, Learned Counsel appearing for the petition has submitted that the matter may be accommodated for accommodated and taken up on another date, since there is a possibility of settling the matter outside the court. Mr. R.C. Saikia, Learned Senior Counsel, assisted by J. Kalita, does not object to the aforesaid prayer. List this matter again on. Yes, sir. Any particular date you want?
My lord, that is lordship fixed.
We'll have it on the 6th of March. 6 March,
Alright.
on 6th of March.
This type of cases should be compromised. Because he's occupying the land. He has to forget.
Yes, any objections filed?
We have
Yes.
filed an objection, right?
Ah,
Because they've brought some unrelated issues. Maybe I'd like to file an affidavit on that.
Hmm.
Seba was also asked to obtain instruction on the last occasion because the issue is whether, because Seba is claiming on one end, is claiming that my registration is not genuine, but mark sheets, etc. are genuine.
My
And
lord, a report is in the repetition itself, my lord.
in the,
Yes.
Sorry, my lord, this
In the-
criminal petition,
where is it?
page 62, madam.
page 62 and 63.
Did we hear this matter before?
Yes, yes, Joshua had this matter. What had happened?
The registration number is wrong,
Wrong. But
but everything else is correct.
correct.
So why would he keep everything correct and then have a number wrongly printed?
My lord,
Any difference in the age, marks, division, attendance, we understand. Printing of the number is wrong.
yes,
In fact, my lord, the petitioner, the complainant, he was supposed to have appeared in, when he got this certificate registration in 2004. I appeared in 2010.
Huh.
And this complaint has been lodged in 2024. There's a
Now,
huge-
all said and done, assuming you forged it,
Yes.
when everything else is correct, the name is correct, date of birth is correct, marks are correct, everything is correct, registration number is wrong. Tell us what benefit would he have?
my lord, some time may be gone. My lord,
Eh?
we'll go through the record, my lord, and file
Because
our-
if a man forges it deliberately, if he has forged it, to what benefit? Yes.
And I got a job in 1983, much before I passed.
My lord, the problem is that, my lord, in this case, my lord, the present petitioner, my lord, forced my registration card. my lord.
Ah,
That is the issue, my lord. Why he forced, that is not the issue, my lord.
we are not
The
on
issue
that.
forced his registration card or not. This is the main issue, my lord.
Ah,
If he not forced, the trial court is competent enough to acquit him. If he forced, the prima facie is that he forced this document. When, my lord, this registration certificate, he used this first my registration certificate and passed the matriculation, my lord. But when, my lord, that was, my lord,
you are trying to say his name is not Awal Hussain.
yes, my name is Rukun Mia, my lord,
Huh.
issued in favor of me.
Huh.
That, my lord, what happened, my lord, at that relevant point of time, my lord, the SEBA has no such mechanism, my lord, whether a registration falsely used or not, my lord. When, my lord, might be, my lord, it might perhaps, my lord, the present petitioner is a fourth grade employee of an school, my lord, where this school is the examination center, my lord.
Huh? You have filed an affidavit.
Yes, my objection.
You have filed an objection. You would like to reply to it.
The reply is otherwise not connected. He has brought on some other cases which have got no relevance here, my lord.
Hmm.
Trying to say that I don't have, I have criminal background and something like that. But the fact remains that's a land dispute, my lord, where I have been made a party, my lord. Well, that's another issue. But here the issue here is, my lord, that his registration certificate is 2004. I appeared in 2010, 6 years gap, and everything else is correct. Now, had I suppose
Even the name.
even the name in my in the matriculation certificate, etc. Everything is
Eh,
correct.
Seba,
yes, my
tell us one thing. If we remove that 3028 at page 62, this 3028 goes number. The rest is all correct. Is it?
look, only this, after going through this report, only I am submitting. my lord. And in the next page also, my lord, 63, my lord. Here, my lord, the registration hearing was issued by the Board of Secondary to Mohammed Rukun Mia, not to Awal Hussain. Registration card attached along with your letter, that is the Mankasar police station, my lord, send the letter. In the name of Rukun Mia is genuine, and the registration card in the name of Awal Hussain is not genuine. As per both rule, there is no provision to allow for appearing in the SLC examination by using a registration number that was issued to someone else. Original registration card of Rukon Mia and the counterfeit copy of.
Based on this, sir, why should we interfere when
Page
there's?
62, my lord, page 62.
Huh?
Further, it is informed that there exists no mechanism to detect incorrect registration number in the board. What I'm trying to say is that if I am able, suppose I force this, let us assume for a moment I force the registration certificate. I get an entry into the examination hall. Up to that, it's okay. But how can my mark sheets, etc. be correct? It cannot be. It will be then in the name of Rukon Mia, not in my name. If the entire thing is manipulated,
So this has to be done in the trial.
no, the issue here is whether
Then
in view
how
of
do we
these
post the-
materials, whether in view of these materials, I need to face go through ordeal of criminal proceedings. Because my registered matriculation certificate is absolutely fine. I have used this
I
document.
think you should file your objections, if any, because otherwise, without a trial, all these issues that you are taking up, I think this court,
No, because no,
Comment
if
on
the
it.
SEBA has done some mistake, let's say. If
the
they can
mistake,
clarify.
that mistake has to come up in the trial.
But they can still say it here, because otherwise why?
They are saying that it is not our mistake. The space 63
Yes.
simply says that it is not yours.
No, it says the registration certificate is not mine, but the matriculation certificate, etc. are mine.
Could
How
be.
is it possible?
Either,
Because
that is what the
that-
trial would find out.
the
We will
problem
not.
is that if they clarify it,
Hmm.
the SEBA, that's why the SEBA should at least have some clarification.
Hello. Hello, the.
Mr. M. Dr. Learned Counsel appearing for the petitioner, the respondent number 2 has filed the objection in the matter. However, the SEBA has not filed their
15.
affidavit or objections. Good stop. List the matter again on when?
My lord. 3 weeks, ma'am.
Give us a date.
Five, 5th
Eh?
of March, my lord. 5th of March.
5th of March 2026.
Obliged. Obliged. You may produce the records also will if necessary. This SEBA. That will make
Yeah, whatever you have to. দুটা গেলে এখানে উপরখন দিয়েছিস না? Yes, sir.
May I please, Lord?
Hmm.
Here, my lord, the petitioners, my lord, sister-in-law, mother-in-law, and brother-in-law. Husband is not before you, lordship. DB case has been initiated, my lord, and all the players, my lord, relief sought for from the husband. Lordship, kindly see page 31. Page 31, my lord. Nothing has been paid from in-laws, my lord. But the learned trial court, my lord, took cognizance against all the family members. Therefore, we have approved this honorable court, my lord. Let the proceeding go against the husband, my lord. We have no objection. Regarding in-laws, my lord,
You are appealing for?
For the respondent,
What do you say?
my lord, in this case, the respondent is the agreed person while filing the domestic violence case by impleading all the petitioners herein as opposite party.
Where? Show us what is the
Yes.
what is the allegation against the
Yes, yes.
page 26, my lord, paragraph 18. Basic allegations. Not against in-laws, my lord.
No, my lord, if you lordship will back to the paragraph 13. onwards.
1-3.
Paragraph 13, page 22, page 20, page 23 of this petition. Lordship will find there are a number of allegations and the role of all the petitioners in the said case, which is pending before the learned trial court. There are specific allegations. So until and unless
Just a minute.
only cognizance has been taken, no charges have been framed. So the petition is premature, my lord.
Domestic violence case, SARS is not framed, my lord.
Huh?
In domestic violence case, SARS not framed. Complaint filed, cognizance taken, then my lord, evidence and pass order as printed. Basic prayer, my lord, maintenance. And she also filed 125 proceeding.
There you are a party, no?
No, we have filed our objection. The husband, my lord. We are not party.
That is exactly what we are trying to find out. It is all a we.
Yes.
When it is all a we, go and defend it.
Oh, my lord, in the prayer, in this case also, my lord, in the prayer portion, my lord, no relief has been sought from the in-laws, my lord.
There is a allegation at page 6,
My lord, allegation and prayer, my lord.
22.
When, my lord, there is no prayer
There are two things.
Lordship.
We have to take notice of a few things.
and punishment is not here, my lord, there is no provision for punishment.
So why? So what is the difficulty in appearing and?
We are appearing every day, my lord.
That is what the law requires.
The result will be
That
futile,
is
my
that
lord.
is that is that is.
Because if there is no relief.
Have you did you file any application before the trial court saying that no, it should not be against us, we should be discharged? Any application filed? It's a state high court.
No.
Then
The proceeding, my lord, continuation will be abuse of.
you go and tell her.
So
You
that
go
will
and
be
tell
abuse
the,
of
you go and
process.
tell the trial court.
And
You tell it there, not here. You tell the court that why take it against us? Discharge us. There is no allegation.
And-
Then the trial court would say that yes, this is the allegation, there is no allegation. Something it will say.
and if we-
We'll find out.
it is a specific case, my lord, that she is living separately since 2023.
Put all this before the learned trial court. Ask for a discharge. That we should not be involved in the case. You are not giving the trial courts any chance. There are allegations that you have been brainwashing, you have been making him do this, making him do that. Is it not? Is it not? So the trial court has to hear you. No.
Lordship, kindly see in her petition, my lord, paragraph 18.
Paragraph?
Paragraph 18, my lord,
Yes.
page 26.
Show this to the trial court. Give the trial court a option.
Even considering all this, my lord, cognizance has been taken.
So if it has been considered,
Before-
if it has been considered, are we sitting here to say that the consideration was wrong? Are we here to say that this is the amount of evidence?
my lord,
We are in revisional jurisdiction. Is it not? We will see properly done or not.
we have
The learned trial court wants to know. Yes, sir, tell us that there is an allegation you are misleading the husband, you are doing this, doing that. What do you have to say? What is wrong in that?
now ultimately, my lord, relief, my lord. What relief you got from the in-laws? Nothing.
Now, if you want us to spell out, if you want us to answer that question, let me answer that
So,
question.
proceeding.
That even the other respondents will not delineate the property by depriving the victim.
No, she will get the property of husband. She will not get property of in-laws.
You will not delineate. You will not throw her out of the house.
Already
That she can get.
Lordship,
Is it not?
from the husband.
It
she will
is not
get-
inheritance we are talking of, sir. We are talking of an order against the mother and the sister-in-law. Plain and simple. Don't throw her out. Is an order which can be given by the court. Can it be given? Can it not be given? Before giving that order, should you be heard or not be heard? Should you not be before the court? Or it will be done on the air without hearing you? The moment we say you are not supposed to be there as parties, you will throw out. Husband will come and say, I have done nothing. They have thrown her out. High Court has set them aside from the case. You cannot touch them. She's back on the road. Is it not? In that case, should you not tell the court that we will do nothing, just strike out our names? We are assuring we are not involved. If the court doesn't listen to you, if the court does not evaluate what you have said, then it is a revision.
We have come for quashing, my lord, under inherent power.
We don't find a ground to quash it. Because the allegation is that you are helping him do it. That has to be evaluated by the trial. In the trial, is it not? Can we evaluate it now?
The prima facie, your lordship, satisfied from the.
We are not. Para 11, the brainwashing part, the instigation part, we are not convinced that you should not be allowed to give a. Convince us.
Lordship.
We are again opening the
Any
file.
other
Convince
thing,
us.
I will produce some judgment, my lord,
Huh?
regarding this point, my lord. Against the in-laws, my lord.
Hmm.
Let me take
When?
it any other.
When?
Next day.
March 13.
Lordship.
Huh?
Lordship.
13th of March.
13th, Lordship. And 11th, my lord, it will be Wednesday.
11th of March.
Lordship.
At the request of the learned counsel for the petitioner, who has sought for some time to apprise this court, to place before this court relevant citations on the matter, list the matter again on 11th of March 2026.
My lord,
Unless you appear, unless you give your statement before the court, how do you know?
my lord, the said citation may kindly be provided to me
Eh?
before the date.
You will have it in the court.
I have to revert it.
Huh?
I have to revert it.
Take your time. Yes, sir.
Matter was subsequent on 4th. Your lordship kindly see the order dated my lord 4/2/04. Honorable Justice Jahan, my lord. Heard and my lord, my part was completed. Just to clarify one point, my lord, we were asked. Probably, your lordship kindly see the order, my lord. That matter, alia also, your lordship also heard, my lord. The person who is the, my lord, victim, he himself is a, my lord, IO,
Oh,
that case.
some police station they entered, something like that.
Yes, correct.
Yes. What happened to that first FIR?
No, not post FIR,
The first FIR.
first FIR.
My lord, here, my lord, that is, the allegation is that, my lord, the two numbers of affairs are there. One is, my lord, taken by the, my lord, police station, my lord. Because the, my lord, that is the accused person who is the, my lord, MLA, my lord. And because of that, my lord, he, my lord, entered into the police station and, my lord, the victim was beaten, my lord, before the police. So now they stated that two numbers of affairs are there. In this connection, my lord, we, my lord, make a request from there to verify whether two numbers of affairs are there or not. Because in the, my lord, that is, my lord, that is the TCR available, it is not found that if maybe, my lord, if two affairs are there, that may be one may be regarded as a 161 statement, my lord. That part was not available. So, my lord, I pray for a sort of accommodation. In the meanwhile, we'll take a report, my lord, in this matter.
From what we have understood in the last order is
My lord.
that the charge sheet has been given in the second FIR.
My lord, but that is not available in the TCR, my lord. That, my lord, that is the second FIR, which is, my lord, annexed with the, my lord.
So the charge sheet has been given in the first FIR.
My lord. Contents are, my lord, same, my lord. Contents
No, not
and the
same.
facts are same. Only, my lord, there is the difference is that one is taken by police, my lord. Another one is by the victim, my lord. Now, my lord, that is the first FIR, which is claimed as a first FIR, my lord.
Is the victims.
That is the victim. But, my lord, that is the police station case number is same, my lord. In both the FIR, my lord. Police station case number is same, my lord. So, my lord, that part in the, my lord, that is, my lord, GDE entry also. I didn't notice, my lord, that if, my lord, some cases, my lord, victim may also file. And in the case, my lord, as because, my lord, incident occurred in the, my lord, police station, my lord. In that case, my lord, that was an outpost, my lord. And from the end of the OC, my lord, that was, my lord, filed, my lord. So, my lord, allow us some more time, my lord. In the meantime, we take a report whether two numbers of affairs was lodged or not, my lord. That is the thing.
In the meantime, my lord, already the parties, my lord, because it is there some misunderstanding FIR was lost. And in the meantime, they have filed one, my lord, understanding, my lord. That was, I have filed in one additional affidavit that is not on record, my lord. So along with that, my lord.
Heard Mr. T.J. Mohanto, learned counsel, learned senior. Yes.
For respondent number 2,
Huh?
I have received additional affidavit just today itself in the morning. So we have an objection. We need to go through and we have not got any instruction, such instruction that amicably have settled. So we have to file an objection.
No, you have to have your instructions.
Yes, Your Lordship. We'll get the instruction from my client.
Okay.
We need some time.
Okay. Heard Mr. T.J. Mohanto, learned senior counsel appearing with the assistance of Mr. NH Borbia. Learned Counsel paying for the petitioners also heard your name, madam,
Please R.H.
paying for the respondent number 2. And Mr. K. Bushra, learned additional public prosecutor for the state. The learned additional public prosecutor has sought for some time to have further instructions in the matter. The learned counsel for the respondent number 2 has submitted that they have received a copy of the additional affidavit filed by the petitioner today morning and would like to have the instructions. Accordingly, list this matter again on. You have sought for time, tell us.
My lord, till now, my lord, no, stay orders passed by this honorable court, but next date of the trial code is 23rd.
23rd of February.
February.
Tell us.
Before that, my lord.
20
20th, my lord.
on 20
My lord.
20 February
20th,
2026.
my lord. Deeply open.
The counsel for the respondents and the additional PP shall have their updated
My-
instructions by the date, since the next date fixed is on. Next date for the trial court is fixed on 23rd of February.
23rd of February.
We'll keep it in the order, and the next date we'll remember what to do. Yes.
I have challenged the order of the trial court below.
Huh.
My Jima petition for release of my truck was rejected.
Is the vehicle required?
My lord, in this matter, my lord, we have received a CD. Some time, my lord, to go through that, my lord. CD receipt, my lord. We received the
No,
CD.
we need to know whether you are required to retain the vehicle or not.
Yes, my lord. That part only.
Only that part, whether the vehicle was modified enough to aid, or was it a school bag inside the vehicle?
For that, I need to take your lordship to two documents which will clarify that.
Before, but without him going through the
I will
instructions.
make my submission after.
When?
Right.
You want it today or day after tomorrow, Mr. Bushra?
Day after tomorrow, then.
Day after tomorrow.
Yes, my lord.
Day after tomorrow, I will not be available then on 22nd.
Yes,
23rd, my
22nd. Mr. K. Bushra, learned APP has submitted that the report has been received.
Right.
And you would require some accommodation. List this matter again on the 22nd
February.
on the 22nd February. We refuse to take it up.
It may be taken up tomorrow.
Not 22nd. It's a Sunday. Why do you want us to work on a Sunday?
Then at 2, lordship.
Today? Not today at 2. You can have it on 23rd. You can have it on 20. You can have it
Then
on
any date after 21st, because I will not be available from 19th to 21st.
21st.
Any
Before
date after-
21st.
Any date after 21st.
So we are giving you 23rd.
23rd.
23rd of February.
Well, CD may be retained till
The
then.
CD will be retained by the learned APP.
My lord, deeply open.
May I please your lordship?
It was for the report from IO
Hmm.
regarding the mobile phone and some other documents.
Yes.
13.
Yes, Mr. Sharma, you need the mobile? If so, why?
After a few minutes, lordship, I'm trying to locate the
Okay,
file.
after some time.
After some time. I'm sorry, lordship.
You have it? Yes.
Lordship, that report was called for, lordship, it has not been received.
Hmm.
That report is not yet received. The lordship might give us a short date, lordship, will give the report.
What is the allegation against them?
The allegation is, lordship,
Why was it seized?
lordship will find it at page 10. Lordship, UAP Act is there.
Maybe required. We don't need. UAP Act.
But he was in bail, your lordship, and mobile has nothing to do with this. It's already in
The mobile was recovered from you.
your lordship.
Is it not?
it's been-
Yes.
And he must be having a mobile now. What is the hurry with that mobile? Yes.
Because UAP Act is there, lordship. for-
That is what you are saying. He must have been having another mobile now. What is the hurry in getting back that mobile?
And in all probably, lordship, the mobile phone will sent for FSL. lordship.
FSL,
And,
yes.
if that is so.
When do you want it?
It's a lordship direct. Lordship. A report may be called for.
27th?
Lordship.
27 February?
Thank you.
Mr. B. Sharma, learned APP has prayed that the matter may be taken up on 27th February, since the report from the investigating officer is not available, and there may be a possibility that the mobile has been sent for FSL full stop. Please again on 27th. by which time the learned APP shall ensure the submission of the report. Yes.
This petition is regarding Jimma of a one pulsar bike and a mobile phone, my lord.
Hmm.
On the last occasion, police report was called for.
No, whose mobile phone is it?
My mobile phone. I'm the purchaser of this mobile phone, and the bike is also in my name.
So why was it seized from you? It must have been seized for some reason.
My lord, FIR is a page number 9, my lord.
Ah,
Lordship, may kindly see the rejection order at page 21. Paragraph number 5, Lordship, page 22.
Page?
22. This
Ah.
is the rejection order, Lordship, paragraph number 5. Thereafter, Lordship, paragraph number 8 is also relevant.
Was it an accident or was it a case of chain snatching, something like that?
Chain snatching probably, Lordship, because Lordship will find it at paragraph number 8. The CD shows that this is a case of sudden attack upon a senior citizen of 68 years in the evening on the road by two unidentified males who came on a two-wheeler. As a result, she fell unconscious on the ground. Her left femur bone around the hip area was broken. The biker snatched away her gold chain. Now, Lordship, paragraph 10. During the investigation, the police had seen the CDR analysis and CCTV footage analysis on which basis the above named person were arrested. Among the seized articles, there are 2 helmets during the commission of the crime. Pulsar bike bearing so-and-so is also completely visible in the CCTV footage, which is also seized in this case. Asadul Islam even tried to flee, so-and-so.
What are they asking Zimma of the helmet?
No, Lordship, the bike and the mobile. That will be difficult, Lordship, for investigation.
Sure, either, my lord. My passenger was snatching the.
And Lordship, these are primary evidence, Lordship. So far, I have gathered from the.
Rapido bikes are being used to snatch. Too far-fetched. Yes, report is there.
Report is not there, Lordship.
We'll await the report instead of rejecting it today. The learned APP has submitted that the report called for is awaited. List again on 6th of March.
Lordship.
Awaiting the report.
Item 15.
Yes, charge sheeted.
That is kindly taken after some time, my lord. On
Huh?
behalf of SC Business, he's on legs, my lord.
After some time. After some time, Mr. Goswami.
17.
Is here received?
My lord, so far as the respondent 2 is concerned, there is no official. They are the service.
Yes, Lord.
This is directed to verify the LCR has.
Published to be received as a office of completion. We have to take instruction whether service is completed or not. So
Huh?
we have to take instruction then service is completed or not, Lordship, because no office
The
is there.
service report of the on the respondent number 2 is yet awaited. The trial court records have been received. List again on when?
Lordship, then 25-2.
On 25-2, awaiting service report on the respondent number 2.
Public.
18.
Hmm.
18 years old.
Huh? Yes, what do you want to do? Charge sheet is submitted.
Copy of charge sheet will be confirmed.
The learned APP submits that the case has been charge sheeted. Call
Yes.
for the white CS number so and so.
12 public 25 dated 8 to 26.
Hmm.
26. 12 public 26 dated 8 to 26.
Call for a scan copy of the TCR. Registration call for it. A list again on when?
March, Lordship.
March
5th of March.
5th.
Lordship, I'm sorry, then maybe taken up at 2nd of March instead of 27th.
Oh, instead of 27, earlier case, make it 2nd of March at the request of the counsel for the petitioner. Oh, I do POCSO to say. Awaiting service report korilu.
This your lordship. Petitioner is behind a bar. Accused person behind a bar 9 months 26 days. Approximate till today. So honorable court kindly complete a report length of detention. Any conditions I am ready to willing to provide.
This time on again.
You appear.
Yes, Your Lord.
Who is the affair?
Affair is it
Yes.
Lordship, Your Lordship, charge plate on 9/25.
Hmm.
So on
Huh?
section 6 of POCSO. So next date is 6 to 26 for evidence, not a single witness examined yet, Lordship. So at least victims should be examined in this case, Lordship.
several times the learned court below issued summon to the PWS, but they have not appeared. In the meantime, honorable court not released the bail to the accused person. How can we face the fair trial?
How can we?
Face the fair trial and give the
Have you seen the allegation? Trial is something given by the act.
in this case, my lordship, page number 27,
Ah,
the statement of the victim,
ah.
27, last line.
TCR এখন চাওচোন, huh? Huh? Within 24 hours. Yes, this 24 hours part, tell us.
he forwarded. He was produced. As per page 23, forwarding everything.
Or was the second case a follow-up of this case?
So already
Where is it? Page 24.
Yes, page 23, this is dated 24/11/25.
Huh?
Forwarding report. And page 24, you also will find, therefore, preliminary inquiry, last 2 lines, my dear Lord.
Preliminary inquiry, yes. Therefore,
this
the
breakup
above
last 2 lines.
is
Due to busy with another case, investigation there delayed in submitting FIR, hence the case is,
no, there was no delay in submit FIR.
there is no delay in submitting.
Submitting FIR was on
Production.
22/11.
He should have been a production, my lord. There is a
Delay in production is there.
delaying production is there.
production.
That has not been explained. That is what we are saying. He must have put the persons in the station and moved by lodging an FIR. Now the IO has to produce. Is there a necessity that that the arresting authority has to produce? In case he is not able to, someone else will produce. No one produced.
My humble prayer is that charge sheet also submitted.
Huh?
So record will be called for, we'll go through the records and these things will be verified on the record.
This is on the face of the.
Sir, personal liberty, direct violation.
Your
Huh?
lordship, paragraph 8 of your lordship's order. Same thing. Paragraph 8.
That if we wait for all those documents unless you want to verify, just to verify. If we wait for some documents to come to us,
Yes,
are we not prolonging that violation? Will be part and parcel of it.
that is right.
What to do? You want to verify these dates?
Yes, Lordship.
If you want to verify the dates, we can have it tomorrow morning at the best, or maybe today at 2 o'clock, or maybe the last item on the board. Otherwise, apparent 22/11/2025 he was arrested. 22/11/2025 he has been. The FIR has been lodged, and he was produced on 24/11/2025.
Tomorrow
And
morning.
there is no reason given
Yes.
for the delayed production.
That is,
Even in the FR, in the forwarding report, it is there was delay in lodging the FIR, not the production. And the magistrate does not look into it. Even he does not look into it to say that yes, 24 hours have passed. Where was he?
Certificate will have to do that.
And in violation, there is a provision to. We'll have it at when? 2.
what's it then?
2. At
Tomorrow
2.
morning, Lordship.
Tomorrow first item, sir. Let him have his instructions on at least. We are not doubting it, but he must be able to say yes. Let's this matter again tomorrow on 17th of February 2026, allowing Mr. Goswami to have his instructions in the matter.
Motion column.
Huh?
Obliged.
Huh?
Your Lordship. 483 application, Your Lordship, FIR lodged under section 25(1) of Arms Act, Your Lordship. The accused is behind the bar for more than 32 days, Your Lordship. I'm not sure if the CD is available, Your Lordship.
CD not received, Lordship.
Is it a firearm? Any ascertainment? Is it a firearm?
In the FIR, it has been mentioned that.
He is a welder.
Yes,
Yeah.
He must have made something to look like a firearm. Is it a firearm? Is it capable of firing? If yes.
So we have not received the case diary, Lordship, from Kokraja. Fix it that we try to produce the case diary.
No, we asked that question only for one thing. That he had something which looked like a pistol.
Pistol. Resembling. He's a welder.
Which looked like a pistol. Now, if it is to shoot out pellets, if it cannot burst a firearm, the forensic would be necessary, I think.
Yes, Lordship.
Has it been sent?
Yeah, Lordship, but the trial court order, one suspected handmade firearm resembling a pistol.
No, this is without anything to do in this case. I know of a matter. I was not involved in it. I heard about it. There are cigarette lighters resembling a pistol.
Yes.
Man was arrested. It took around 21 days for the forensic to say that it's a lighter, it's not a firearm. And there were no other allegations against that man.
Yes.
Save and except he was carrying an illegal firearm and he was arrested during a routine Naka check.
It was
Some
counted lighter.
altercations might have taken place. There was a resemblance quite appropriately taken into custody because it resembled something. But that verification took around 21 days.
Only thing is that after perusal of the case diary and case record, Lordship, and a trial court has rejected his PR. Yes. That is,
If it is a firearm, we cannot risk someone on the road with an illegal firearm. But if it is not a firearm,
then.
So when can we have some, when do you want it? When were you arrested?
I was arrested on 15/1/2026, Your Lordship.
15/1, yes. About 30 days.
24th
of February. Just have a, if the report can be had whether it is a firearm or not. It may be handmade.
He has not been received, so it will be taken up day after tomorrow to produce the paper.
We have been informed the CDS anyway, my lord.
Uh-huh.
Day after tomorrow is saying, my.
Ah.
They have been informed that CD has been received. May I know the source, Lordship?
Who informed?
Anyway, that let him might take.
Who informed? Who informs you?
Anyway, my lord, we
Let us-
cannot be put on record, my lord.
No, no, we are not there
Yes,
at all.
yes.
But,
Day after tomorrow he is saying.
at the request of the Leonard APP, this is the matter day after tomorrow. The APP shall endeavor to have the CD received by that time. Mr. H.R.A. Chaudhary, Leonard Senior Counsel, appears for the Senior Counsel assisted by Ms. So-and-so, appears for the petitioner.
26 and 27.
But there are two items, 26 and 27. We
Ah.
have 26, madam. I am for 27.
Lordship,
Hmm.
sorry, before they start, Lordship, I have gone to the records, Lordship. This CD part will be necessary. Only, Lordship, the statement of the seizure witnesses are there and not the independent witnesses. So that may be called for, Lordship, because that will be required.
Our case is, his case is already succeeded.
Hmm.
His client is already in the jail, madam.
Hmm.
I am formal anticipatory bail, madam.
Hmm.
I am not on interim, madam. As the case is succeeded, my lord,
Ah.
and my information is that, my lord, under NDPS case also, my lord, case has been registered. Other section will be, my lord, bailable. The offense of NDPS, my lord, by the special court only. So if I appear, my lord, there is every likelihood, my lord, I may be put behind the bar.
But if the charge sheet is already submitted,
Yes.
and unless there is an apprehension that you may not want to face trial.
I want to face trial, my lord. Only thing, my lord, from the affair itself, my lord,
Hmm.
whether, my lord, any material is there under the NDPS Act or not, my lord. Some tobacco containers were received. No tobacco materials were, my lord, seized from anyone. In that case, my lord, whether
Arms Act is also there, Lordship.
Hmm?
Arms Act also, my lord, I think is certain.
That is what we said, it may be lighters.
No, edit section is there.
But whether
Edit section,
Yes, edit section, it was added subsequently.
in the charge sheet,
And 12,
arms
in the charge sheet, in the charge sheet.
I have to see, Lordship.
In the charge sheet, we need to know if there is no arms act and if it is empty tobacco containers.
Yes.
my lord, that arms, my lord, alleged arms were, my lord, recovered from the.
And what was the invalid document of the vehicles? Was it regarding this pollution not done and this not done, that not done, or whether there is no owner of the vehicle at all? That we
Our
need.
case is that, my lord, because of the construction of the, my lord, the highway, my lord, some motorcycles were, my lord, parked in front of our residence, my lord. Those were seized, and, my lord, there is no report of any theft, etc., my lord.
But he is asking for
Yes.
the statements.
Lordship, because otherwise also, Lordship, even if the Arms Act is not there,
Hmm.
is registered under Lordship 3174, which carries a maximum punishment of 10 years and above.
Hmm.
Lordship, for that purpose only I am submitting, Lordship, the statement may be called for. Lordship, otherwise, what has happened, Lordship, the one of the petitioner is in custody, it is BA, Lordship, and the other one is anticipatory, Lordship. And he appears to be the mastermind, and they are engaged in organized crime of taking up this motorcycle and selling it in spare, Lordship. The petitioner who is under custody, he sells of the motorcycle in parts. That is the entire allegation. And I have gone through the case day, Lordship, their Lordship, from his shown by the BA, Lordship, petitioner in the custody, some live ammunition were also recovered. That is in the seizure list also, Lordship. 5 numbers of live ammunition was recovered, and Lordship, some cash amount were recovered, which they are tying it to NDPS item because he is a habitual offender under several other cases. That is the
That is there in the
yes, yes. That is
the person who is on
custody.
Who is in custody?
Yes, he is engaged in, involved in other NDPS cases. So that is the gist, Lordship. But Lordship, without perusing the statement of the witnesses as to what the investigation has come up, Lordship, that will be difficult.
Now they have recovered life cartridges.
Yes. I have
Yes,
checked my.
Let him, let him.
that is in the affair itself, my lord.
Yes.
Only thing, my lord, as charge sheet has been submitted, my lord, we are ready to face trial. My lord.
Ah.
In that case, my lord, whether any fruitful purpose will be served, my lord. Or
Here we don't need to keep it. The person already in custody can move the trial
Yes,
court.
that is open, but
And
regarding,
the person who has not yet been arrested,
yes, the AB. AB Lordship, he can always appear before the court below and.
he can appear before the court
court
below, and
will
we can
consider
make
it
an
on merit.
we can make an observation that the anticipated bail petition would be considered on the basis whether he is likely to face trial or not, whether there is any.
my lord, facing of trial is there because charge sheet has been submitted.
We are
Only
not on
my
that.
NDPS case, my lord, I am on that, my lord. Because NDPS, my lord,
Ah.
absolutely, my lord, there is no material. Only some containers will seize. In that respect, my lord, if it is a magistrate triable case, my lord, I will, my lord, face the trial, I will cooperate with the trial.
If Lordship NDPS comes into picture, then obviously.
From
Lordship,
where? You have to show us something from where. NDPS part, where is it coming in from?
NDPS part, Lordship, because the.
Just because money is found.
Yes,
Just because there is some money. Dangerous proposition, sir.
yes, only that much, Lordship.
That is
That I
a
have
dangerous,
seen.
that is a dangerous proposition.
Lordship, NDPS, Lordship, I am not placing reliance right now, Lordship, because obviously, Lordship, the sale proceeds or the money that has been recovered, they are assuming it to be.
If the allegation is that the bikes are sold in spare parts,
Yes.
the source of the money is revealed. Why
Yes.
bring in NDPS into it?
NDPS has been bought, Lordship, because the person who is in custody, he is involved in other cases, Lordship, several other cases.
That will be considered on its own aspect, but the person who is not in custody.
Yes, the AB, Lordship.
Ah,
AB part, Lordship, NDPS may not be there,
Then-
but Lordship, the 10 years above conviction is there, the section is there. So in that.
for what? For which of the,
For
for
dealing
which?
in, Lordship, stolen articles, knowing fully well that it is stolen articles, habitually dealing with it. That carries
That,
maximum.
that will take its own course. We have to prove knowingly, willingly. All has to be, it's all a matter of trial, but as of now,
Yes.
yes.
Lordship, I appear for the person behind the bars. What has happened, Lordship? On secret information, search was conducted in the place of his residence. There, certain vehicles were found, empty tobacco containers were found. So then I was called to the police station after 20 days. I go to the police station and I was arrested. On the basis that I have telephonic conversation with the prime accused who is outside. Police went to his house, but he absconded due to darkness. That is what the FIR states. Later on, because empty tobacco cases. were found-
NDPS part, we are not impressed.
Yes, that is.
And I am for the last 55 days behind only because of I was in contact, telephonic conversation with the person who is outside.
Just a minute.
Nothing was
But
recovered.
regarding, Lordship, the entire allegation is, Lordship, that the person who is on AB is trying to get AB. He, Lordship, lends money to people. Thereafter, Lordship, just facing a fact, Lordship, when the money is not paid, he extorts the persons and takes away their vehicle, and later it is sold by the other co-accused. That is the allegation.
Just like some of the explanations given in the petitioner
Yes.
seem a bit, we will not use any words.
Only because of
This
that,
story is not fitting in.
only because of that, Lordship, I had stated that I want to go to the other witnesses.
When?
If that
When?
can be, Lordship, it will be called by the registry, Lordship.
Huh.
No, sir. I have seen the witnesses, Lordship. There are number of witnesses. Only the seizure witnesses are there, not the other witnesses.
So that is what independent witnesses would be. Independent witnesses of what?
Independent mean, Lordship.
They would be independent witnesses of what?
Lordship, person who
They are not part of the seizing team. They are persons standing outside the seizing team. That is the independent witness.
Lordship, who has made the complaint, Lordship, regarding the extortion part, taking away their.
There is no.
There is no complaint.
There is no complaint. No.
There is no allegation. Show us from the FIR that they, complaint received, you had moved.
Lordship,
No, it is on secret information. They went to his place, his
Huh.
residence, and they found certain
Lordship,
bikes and cars, which they suspect to be stolen.
Page
But no one has come forward saying that I am a victim of, and this is my property. Subsequently, only because telephonic conversation, I was called to the police station. I go to the police station, I am arrested. And NDPS, there is no contraband recovered. There is no contraband recovered. Cash was recovered from his possession. I was called to the police station. I go there and I am arrested.
Lordship, the first part of the page 39, Lordship will see that providing limit money loan when the lenders could not return the loan amount with interest, then he dishonest.
This is what the police is writing.
Yes, misappropriated personal
As per the
property.
FIR.
So whether there is some statements which in that effect.
Page 39.
Yes, page
39.
39.
Petition for praying for adding 27.
Just a minute. This is, we are on BA 251.
Yes.
Yes. This is a petition filed by the IO Lordship.
Ah, this is for adding arms act.
Yes.
And nothing was recovered from me, no money. I don't know how they are linking me with the Nexus Lordship. And already 55 days behind. I'll face the trial Lordship, at least my custodial detention may be relieved Lordship.
Now, these motorcycles, they must have owners.
Yes, that is why, Lordship, because I'm clear about the witnesses, Lordship, this real witness I have seen. But there are other named witnesses who are in the charge sheet, but their witnesses are not on there. That's what I'm submitting, Lordship. Charge sheeted witnesses, their witness are not in the.
All done, taking away bikes because of money not being repaid. All of them, you go and you have them tried. Why do you need them behind bars when NDPS is nowhere?
55
That is the only thing I'm worried about.
And they have to link the money with the illicit.
When NDPS is not that, all others, all other allegations,
Either parties.
whether he is required to remain behind bars after 55 days.
Can you see the flag mark?
Hmm.
He led the police team and recovered, Lordship, 5 live ammunition.
5 lakhs?
5 live ammunition, Lordship.
Huh.
That was recovered.
That so many people know something may be there.
That scrap I categorically deny.
Are you connecting him with it? You must take his.
Proceeded under Arms Act Lordship.
And have the anywhere it is stated to whom those bikes belong, the cars belong? No attempt made to find out the owners.
Lordship, that is why
We do it on the road. The moment there is a no parking violation, we do it on the road.
Lordship, normally, Lordship, if the charge sheeted
No.
witnesses statement
Okay,
can
what
be seen,
purpose will it
everything
serve,
will be
Lordship?
clear.
The last
If
55 days.
there are no witnesses.
For bail, we just need to see whether you need them in further custody or whether you need them to be in custody. Charge sheet is submitted. Person who was not arrested during the time of trial, if he surrenders before the court has only to see whether he will participate in the trial or not. Nothing more to do.
And Lordship.
And the person who is behind bars.
And nothing was recovered.
His attendance may be secured and some strict condition will be.
So whatever strict conditions, we'll.
Lordship. Lordship.
Yes. In BA, you write. This is a bail application under section so and so. 483. TCR had been called for along with the case diary. TCR is received. Gone through the same. Yeah. Having given due consideration, this court is of the opinion that the petitioner can be released on bail during the period of trial on the following conditions. Strict conditions that are did. Sessions court, trial court will be entitled to give such conditions as may be deemed fit. AB to Diok.
That will be, the case has now been committed. So special NDPS case number 10.
Bail in
Special
connection with
NDPS.
special NDPS case number. NDPS case number.
Because Lordship, we are 27A. That was charged with
NDPS case number since.
case number 10/2026.
No, nothing, no recovery, nothing.
No recovery.
How do you connect? How do you connect?
Only to curtail me, Lordship.
Yes. AB to shall appear before the trial court. Submit bond of rupees so and so. Bond of rupees. I don't want to get it. Two sureties like amount. Or other conditions that the trial court may impose.
Mobilized.
Pending in the court of district and session judge.
District and session judge.
Jorhat.
Property, district and session judge. Yes.
Deeply object. Highly object.
Well, I'll seek some time because this matter was allotted to Mr. B. Sharma.
Ah,
Today he has passed the buck to me, so I'll require some time. On Friday it can be fixed. I can come with the report or whatsoever.
two things. Every other case of this manner has been withdrawn.
No, there's a issue is there, madam. Those cases, those are criminal cases where state is the party. But forest cases start as a complaint case. Forest department being the complainant, madam. We have to give the authority that we would withdraw. It's not that the other same.
Why are you not giving the authority when every case which started as a criminal case was done?
Because these are forest cases, madam. In
Ah.
forest cases, the law is bit different because
To
if
the
the final the charge sheet is laid till the conclusion of that proceeding, vehicles cannot be released. In fact, this petitioner went to the Supreme Court also, one of them.
Hmm.
It was upheld, my lords. That till the culmination of the proceedings, this judgment of
No, the vehicle release is the second part.
my lords.
The first part is that when others of a similar nature have been withdrawn.
Yes.
The
State
department
government
changes
I'll have to take instructions, my lord. Today it
When?
will send them. Friday.
Friday.
One more thing, Lordship. A observation will be given on the next day, Lordship, my case will be disclosed. Otherwise, Lordship, they are taking.
He will place a few Supreme Court judgments. We can dispose it now
No, Lordship.
on Friday. Because now he'll be hitting here and there. And he'll be producing all sorts of judgments.
Lordship, my case.
Let it be on Friday. He's prepared. We know what we are talking about. All the constituencies.
Always.
Lordship, one,
Please, Taganan.
one more thing, Lordship. On 16/12/2005, this court has been already sought for an.
Head to Kolu. Always, my lords.
Lordship, fine.
CD received.
My lord, 28 and 29, my lord, same person, my lord.
Ah,
Lordship may kindly first take up item number 29, my lord. Because in
29?
that case, 29. In that case, my lord, I was arrested. And subsequent, this item number 28, I have been shown arrested.
shown arrest.
So 273, my lord. BA 273.
Huh?
But it's of Hojai PS.
Hmm.
Hojai to nai, apna 28 plus.
This is the Hojai PS case, my lord. I am behind the bar for 36 days, my lord. The contention before your lordship, my lord. Lordship may kind of have a look at page 17, my lord. Page 17 is the arrest memo, my lord. As per section 35 of the BNSS, my lord, lordship will see the below, my lord, the sign of the IO and the signature of the arrest.
Page? I'm sorry,
Page
sir.
35, 17, I'm sorry.
17, yes.
17, Annex 3, my lord.
Ah.
This is the arrest memo, my lord.
Hmm.
Lordship will see below, my lord, the signature of the arrestee
Hmm.
and below, my lord, the sign of the IO.
Hmm.
On the left hand, my lord, below, my lord, there is a no attested witness, my lord, which is required, my lord, as per the BNSS. My lord. This is one ground, my lord. And second, my lord, the next page, my lord, page 19, 19, my lord. The third paragraph, my lord. Seen the FIR, accused forwarding report, arrest memo, notice under 47, 48. BNSS WT message, my lord. And my instruction is that, my lord, that 48 notice was not served. No
Never.
acknowledgement. WT message. My lord. And this,
Where were you reading that 48, 47?
my lord, page 19, my lord, Annex 5, my lord. This is the order passed by the magistrate, my lord. Fifth line, my lord. Seen the FIR, accused forwarding report, arrest memo, notice under section 47/48 BNSS, WT
The
message.
WT message is there, sir. Do you have the WT message with
My
you?
lord, in item 29, my lord. Item 29, my lord, we have not received the CD, my lord.
Ah.
In item 28, it is, my lord, we received the CD, it is from Lanka PS. And item 29, it is a Hojai PS, my lord.
Huh?
Hojai PS.
Tell us one thing. In item 28,
My lord.
you have shown him arrested.
Shown arrest matter.
Shown arrest.
Shown arrest, my lord. 28 is, my lord, shown arrest matter, my lord. In connection with that, my lord, he was arrested, my lord, from the ATM, my lord, where, my lord, incident happened, my lord.
This shown arrest
He is shown arrest, my lord.
is supposed to be told the grounds of arrest in that part also.
My lord, in 28.
The moment he is shown arrest in any matter.
My lord, there is admitted position.
Where is it?
My lord, in 28, my lord, that party I didn't notice in the city. I didn't notice in the
Notice
city.
it, please notice it now.
My lord, I didn't notice it, my lord, and
You
the
have
my lord,
to-
the order, my lord, it is my lord
Is
reflected.
it
that-
required, would it be a necessity or not?
Yes.
Once he's arrested for anything, he has to know why he has been arrested.
That is necessity. Only
Where
when
is it?
here, my lord, the one order is there, my lord. When my lord, that is the order is passed, my lord, on 18/1/2026 regarding his shown arrest, my lord.
Where?
Page 23, my lord.
Page 23.
Page 23.
How can you do that?
It 28 to question.
Suppose he is acquitted in 29, the charges in 29.
My lord.
He may still be convicted under 28 in the case which is at item number 28, charges whatever are there. Is it not?
My lord,
So he is under arrest in 28 also.
my lord, he is my lord arrest under 28, my lord, as a shown arrest.
That
As-
is what we are
as
telling
shown
you.
arrest,
That
my
is what you are doing. These are two different cases.
two different cases. One is Hujai, my
So the
lord.
moment you arrest him
Yes,
in
my lord.
28,
28 is shown arrest.
you
Yes,
have to arrest him because if this court gives bail on 29, you will say that no, he's in 28, there is no bail.
my lord.
Is it not? So he's under arrest in 28 also. Shown arrest is under arrest.
Yes, my lord.
Where is it 47, 48?
My lord, 28, my lord, that part is not there, my lord. I didn't notice that.
We can grant bail in 28
My lord,
now only.
my lord.
If there is no 40, if there
Yes.
is no,
Because I didn't notice, my lord.
please go through it once.
My lord.
We'll await for 29.
Yes,
This part, this 29 CD is awaited.
29 CD is awaited, my lord. 28.
And
we received
29 is the
CD,
first
my lord.
case.
My lord, 28 is the
29 is the first case.
29 is the first case, my
And
lord.
there the CD is awaited.
No. That CD is awaited, my lord.
That CD is awaited. Why?
28 the CD is available, my lord.
The video shows him. Have it, but if 47 is not having that witnesses and 48 WT, whether it was served or not. When?
My lord,
Friday, let it be on Friday.
Friday? Possible?
5 days ago.
my lord, Monday, my lord.
Monday?
Monday, my lord. From
Can it be
Hujai.
Monday, sir?
6. Today is 36 days, my lord. Till do.
Monday?
Monday.
Monday. Mr. A. Bush's Learned APP has submitted that he would like to have instructions as to whether the notices in notices under section 47 and 48 in connection with the arrest of the petitioner in VA number 272 of 2026 had been served upon the petitioner at any point of time. The case diary in BA number 273 of 2026 is awaited. List again on Monday, allowing Mr. Bush to have his instructions in the matter.
29.
I'm obliged.
I'm behind the bar from the
Huh?
past.
Huh?
5 months, more than 5 months. Here the petitioner is.
What was recovered?
Here, Lordship, the intermediate quantity 114 grams of heroin and from the possession of the co-accused. So he is also co-accused, Lordship, and it is fixed for evidence. So Lordship may impose some strict condition and I leave it to your Lordship.
It was recovered from from the co-accused.
Yes, from the woman, Lordship. Lordship will find it at.
We saw that.
Yes.
Page 18.
Yes, 218.
Some suspected woman coming out.
Yes, yes. Her
And where was he?
She has bought it from him. That is the allegation against.
She says she has got it from him.
Yes.
We'll allow it.
Some strict condition may be imposed that he will regularly attend the court and.
No.
Yes.
Huh?
I'm also just a auto driver.
Huh?
I'm an auto driver.
Oh. Either you take the chance or you don't take the chance. Yes,
Yes.
it will be upon him to arrange for it. Where is the trial going on?
Silchar,
Silchar, and you are a resident of where?
that, Kacha district.
Kachar, so. Itu bail to allowed? Bail to allowed? NDPS involved, এখানে strict conditions কেটে মান্ডি বলবো, huh? To ensure his appearance, his participation in the trial, since the matter has been charged and is at the evidence stage.
Hello.
Dispose.
May I please understand?
Submitted, Lordship. Lordship, let them appeal the remedy in the court below, Lordship.
Huh?
Charge sheet has been submitted, Lordship. Let them approach the court below first.
You'd like to go and try it there, or charge sheet has been submitted?
Lordship.
What would you like to do?
Lordship.
Huh?
One bill, Lordship. I appeal before the CJM trial court, Lordship.
You'll pay for regular weight. Learned EPP has submitted that the charge sheet by CS number
48/26 dated 12/2/26.
On
Has
Lordship,
been
on
filed.
13, I verify that CGM court and PSI court, no charge sheet is available.
Now he has given you a charge sheet number and a date.
Date, Lordship.
Would you like to verify and come back by Friday?
13, Lordship. In PSI court and CGM court, no charge sheet.
When was
Available,
it submitted?
12/2.
12/2, and you inquired on 13/2.
13.
On 13/2, maybe it was not brought on the record by that time. They must have looked at the register.
Keep this on record, Lordship.
Or would you like to find out and come back?
Yes, sir.
Huh? We can take it up again on Friday.
No, Lordship, I appear before the.
Charge sheet has been submitted by Science and counsel for the petitioner seeks liberty to withdraw this petition and approach the learned trial court. Pay for regular bail. Prayer allowed. This bill petition is disposed of, allowing the petitioner to liberty to approach the trial court for regular bail.
May I please, Lordship? Herein the petitioner, they are the diverse, Your Lordship. One is
Huh?
they are the diverse and co-diverse.
Huh?
And for 702 days, Your Lordship, they are inside.
What had they done? Kindly indicate.
Basically, herein, Your Lordship,
1022 kilos.
1022 kg ganja was, 1022 kg ganja was recovered from the truck.
Which you are not driving.
No, we are the driver and co-driver, Your Lordship. Now, page, Your Lordship, 45 and 40.
Page 45. Yes.
Page 44 and 45, Your Lordship, kindly. This is the notice served under section 50 of the CRPC. 44 is in respect of the petition number 1 and 45 is in respect of the petition number 2. Basically, Your Lordship, I am on that ground here. No such ground has been communicated here.
No ground has been given.
Your Lordship, kindly see, page 44.
Yes, we have seen.
By this notice, they have. And my instruction is that, Your Lordship, the relatives of the petitioner, they were also not intimidated, Your Lordship.
Okay. Yes, sir.
Lordship, the material was confiscated in their truck. They led, they opened the special cell where they were carrying in the truck. What more grounds are required to be given to them? I'm just taking your Lordship to page 23 for a moment.
23.
23 for a moment.
But then, sir, you have to show us when the Supreme Court says that at the time of arrest, they have to be given the grounds. it does not make an exception for recovery from conscious possession or whatever. It doesn't make an exception. If there is an exception that we can carve out.
Exceptions basically based on the facts that lordship has to.
No. Are we permitted to carve out when it is an
Here,
blanket order? Can we cut holes in the blanket?
it's a lordship will be relying upon the cases of Purkasta and all. Bansal, Purkasta and Vihan Kumar. Perhaps this is before that. This is a
23. One of them is 23.
Vihan Kumar, I think of 25.
Bansal, 23.
And no, I don't think so, lordship. I think 20.
Okay. We'll go, we'll take the dates. Give us the date also.
Just pointing out, lordship, at page 23, somewhere in the middle, your lordship will find the ganja was filled in the truck. It is near that signature. Right side signature.
This ganja was hidden in the truck.
In the truck, so and so, 2 days ago, the ganja was filled in the truck by the Labour Party at around 12 o'clock in the night. Manoj had said that it should be, I think, 1,000 kilograms of ganja has to be given to a man named Kalipada Bhandari in village Nala, so and so, Jharkhand. Thereafter, Tahzib and Muhammad Hussain departed from Maram Senapati Manipur for Dumka, Jharkhand. Muhammad Tahzib also confessed that he has been transporting the seized contraband ganja from Maram Senapati Manipur, Dumka, Jharkhand for monetary gains. Accused Tahzib further confessed that the suspected supplier of the seized ganja was namely Manoj and his mobile number so and so. Accused Tahzib also revealed in his statement that the suspected receiver of the ganja package is one Kalipada Bhandari. And
any information given to their relatives, friends, anywhere?
lordship, that the TCR is here, lordship, that may perhaps be.
Regarding that part, your lordship, possession.
I have not gone through the TCR, lordship.
We can afford you some time.
Yes, I will go through it.
Hey, Herik, matok suntak. We'll come back in 2 minutes.
But
Can have a look at the TCR. I'll come back in 2 minutes.
Lordship, so far as the grounds of arrest, lordship, that is all which I find. And insofar as informing the relatives, lordship, they have informed the relatives. We have talked over 4. I marked the pages, lordship.
But even if those judgments are earlier,
those say henceforth.
yes. What do you say on the henceforth part? Show us that the judgments were earlier.
Regarding possession part, your lordship, in para 9 of my petition, I have made a statement.
The grounds of
that they
written,
used to
grounds
drive
of
the-
arrest required in written. We have also passed orders that
Yes.
prior it will not apply. So apart from that, if you have some grounds, you tell us if that is the only ground you are placing. Huh?
The coordinate. And that matter was also the NCB was there, your lordship.
That his argument that it will not apply in that was not taken into account.
In that case also.
There is a
NCB was
justice,
there,
there is
your
an
lordship.
order of
The claim-
Justice Goswami, we can give it to you. It says that if it is prior, it will not apply.
The prior on judgment is there, your lordship, conditions.
Show us.
That-
Show us that for arrests prior to Probi Prakash and Vihan Kumar, convince us, because this will be our discretion. We are not bound as of such.
Regarding applicability of the law,
Hmm. Yes. Regarding applicability of the law,
Worship, I have given the.
which one? Hmm. Tungo some, huh? This is when retrospective operation and all, you are depending on two judgments. Those Prohibitions and all, they have laid down that henceforth, unless it is given in writing, it will be termed to be a violation of 22(1).
Henceforth means, it means your lordship, that's all your lordship, that issue. The problem. Lordship, can it be taken after some time, your lordship, because I have only one judgment, your lordship, which I have given to you. And so I cannot.
Just give us 1 minute. When do you want it? When do you want it?
At 2, your lordship.
Are you here, sir?
At 2 or Friday, your lordship.
Friday. Friday is a easier day. We can pile up matters for Saturday also.
This sir.
We'll try to finish it on Friday.
Not on Saturday.
Not on Saturday. Friday. At the request of the learned counsel for the petitioner, list again on Friday. Yes.
May I please, lordship, today engage counsel Mr. Alan just some personal difficulties, lordship.
TCR has been received at the request of the learned counsel for the petitioner, list again on
Next week.
next week. Not possible. It goes to March, 5th of March. Scan copy. I
Item 43.
report it. Not an accused.
This case, true, search sheet has been submitted.
You are not an accused.
Not been submitted against this petition.
Huh? What do you say, sir?
We have not received that instruction whether this only information or charge sheet submitted in this case.
So on the last occasion, this court had
sir.
recorded,
Yes.
he has not been shown as an accused. They have
When-
not sent you a copy of the charge sheet submitted, or they have not given that
Not received
instruction.
any instruction.
When is this instruction of?
We have not received any instruction.
The instruction you
The
are
instruction
holding?
is only the charge sheet submitted.
When was it?
It was.
Dated what? No, the instruction given to you, when was it given to you?
the earlier-
When did you receive it?
Yes,
Earlier?
Earlier, 11/12.
Huh?
11/12/25.
I have the instruction tomorrow.
Not today.
Huh? Mr. Goswami, Leonard APP has submitted that the information required by the order dated 4/2/2026 can be obtained by tomorrow. Accordingly, list this matter tomorrow. Interim order continues.
35 lot charge sheet submitted.
We are in interim.
Make it absolute. The Leonard APP has submitted that the charge sheet has been submitted in the matter. The petitioner has been on interim protection. Full stop. No, interim protection to order dated 7/11/2025. Interim protection granted earlier is made absolute.
My CS number 249/25.
Charge sheet number 2.
Dated 14/11/25. CS number 249/25. Dated 14/11/25.
56.
We have not received the case diary.
Case diary is awaited. List again on 9th of March.
Interim was granted to him.
9th of March.
Lordship.
9th of March. Interim protection granted earlier continues.
37.
Same.
My lord, out of the same case records, both the matter may be tagged, my lord.
Same. Due to same due, here you same due. Huh?
Here also,
36/37.
38.
here also interim.
Interim protection, same order I said.
Right.
37. Separately.
48.
Case diary received.
It is received.
None request for the petition on call. Case diary has been received. APP to retain the case diary. List again on
Next week, Lordship. 24 to
24th. Interim protection granted earlier
Yes.
continues.
49.
Lordship.
Yes.
Lordship, my scenario is on legs, Lordship. And
So
matter be fixed day after tomorrow, Lordship.
he'll be on legs till day after tomorrow.
Yes, Lordship.
Huh?
You need to go through it more.
Go through what?
we have received the case diary and retained the city.
Case diary received at the request of the Learned Counsel for the petitioner. List the matter again day after tomorrow. Interim protection granted earlier continues.
Hello,
Don't make him stand for 2 days continuously. Yes.
Pass over for the time being, Lordship.
We have not received the case diary.
Lordship, some submission to be made, Lordship.
Huh?
My senior will make some submission, Lordship, regarding this matter, Lordship.
Just a minute.
I'm not an interim, Lordship.
Exercise is there also. Exercise act is there. So exercise participants never.
What does the case diary say?
Case diary not received.
Not received.
Not received. Diagram of PS.
So all the sections are below 7 years, Lordship.
Ah,
So my senior will make some submission, Lordship, after some time.
recovery has been made. He's on the run.
That's it.
Might have been brought for consumption. How many bottles?
Lots of bottles.
Huh?
10 recovery items.
A huge quantity.
One huge quantity.
And further huge quantity. What is the huge quantity? Anything indicated?
In the schedule is only the numbers are there.
Total.
20 numbers of bottles.
Huh?
No, another
From
thing,
house or from shop?
lots of bottles are there
Total is 123 liters.
123 liters.
on different brand.
So 25. 100 bottles.
So next week,
No, he wants it after some time. His senior wants to appear. Huh? At 2. At 2. Let his senior.
Knowledge, Lordship.
42.
Impleted. Impleted? Huh?
Yes.
POCSO? IT. What is the allegation?
It's 12 my lord in the affair.
So we'll dispose it off on that lines. He will continue to pay what he was paying in the,
That's it?
as the interim, whatever he was paying. He will continue to pay that
Yes. And
till
for,
the disposal?
yes, and for minor children, Lordship,
Huh?
That observation is not required at this stage, my lord.
What? Why is the observation not required? So that you can go and say that that observation is not there.
yes.
And then pay a reduced amount, then he comes from running back to the court.
If you, their judgment was learned trial could pass in a that way. Because, my lord,
We'll see what we'll have to do. Heard Mr. Swain counsel paying for the petitioner also heard. Mr. Swain and counsel paying for the sole respondent. The bone of contention in this writ petition is, in this criminal revision petition is the order passed by the Principal Judge Family Court 1 at Kamrup Metro, Gauhati in FC criminal case number 353 of 2022, full stop. Not full stop, on 19/7/2025, full stop. By the aforesaid order, the learned family court has directed the petitioner to pay the opposite party therein oblique respondent herein a month, no, to pay the petitioner therein oblique respondent herein a monthly maintenance of ₹5,000 and another maintenance of ₹2,000 each to the minor children of the couple with effect from the date of filing of the case. The learned counsel for the petitioner in this criminal revision petition has submitted that the order does not reflect that the assets and that the affidavits of assets and liabilities filed by the parties to this litigation were taken into consideration when the learned family court had determined the quantum of compensation, full stop. The learned counsel for the petitioner has further submitted that no reasons have been granted in quantifying the monthly maintenance at ₹5,000 for the petitioner and ₹2,000 each for the minor children, full stop. The learned counsel for the petitioner has further submitted that the petitioner was paying an amount of rupees, how much? 3,000 in total.
Yes.
During the pendency of the FC criminal number 353 of 2022, full stop. The learned counsel for the petitioner has further submitted that the fact that the monthly net salary income of the petitioner is about 7,423 only has not been discussed by the principal judge, family court, while granting a total maintenance of ₹9,000 to be paid by the petitioner. Countering the aforesaid arguments, the learned counsel for the respondent has submitted that it is not in dispute that the children of the couple are studying in schools where, or studying in educational institutions, where each of the petitioners have to pay you are just a minute, if you don't write. You are not telling, it's one is paying 700 per month
Yes, Lordship.
as maintenance, and what about the other one?
Other is 1,000, Lordship.
1,000 per month.
Yes, page number 91, Lordship.
Page number 91. That the children of the couple are required to pay around rupees 700 per month for 700 rupees for the male child and around rupees 1000 per month for the female child. This court has gone through the order passed by the learned principal judge and has found that the affidavits of assets and liabilities has indeed not been taken, has not been discussed in the judgment. The only ground for the principal judge, Family Court number 1, to have granted the family maintenance was that the petitioner therein, oblique, respondent herein had no source of income. It has been submitted at the bar that the petitioner herein has paid a total sum of rupees 19,000. Have you paid that 10,000 or not?
As per direction of this honorable court.
You have paid that 10,000 and prior to that you had paid a sum of rupees 9,000.
Yes.
Huh?
Yes, madam.
Has paid a sum of rupees 19,000 till now from the date of disposal of the FC criminal case number 353 of 2022. Full stop. Since the law requires an evaluation of the assets and liabilities of each of the contesting parties in a case for grant of maintenance, comma, this court is of the opinion that the order dated 19/7/2025 requires an interference to the extent that it did not discuss the assets and liabilities of each of the contesting parties. Full stop. Therefore, this court is of the opinion that the interest of justice would be served in the event the matter is remanded back to the trial court to assess the to take into account the affidavits of assets and liabilities filed by the respective contesting parties as are available in record, and also take into account the other evidence that may be on record before the learned trial court, and thereafter come to a finding regarding the requirement of regarding the quantum of maintenance required to be paid by the petitioner herein. Full stop. In the interim, during the pendency of the FC criminal case before the trial court, it is provided that the petitioner shall pay a sum of rupees
3,000.
Maintenance for the children might not be strict.
3,000 in totality. No, pay a sum of rupees 1,500 to each of his children as maintenance, and a sum of rupees 2,000 to the sole respondent herein during the pendency of the case before the learned trial court.
If it may be extended, it will be helpful, Lordship.
Sorry?
The maintenance of each minor children, if it would be that 2,000 only, then it would be better.
No, we have kept it at 1,500 each. One has a 700 liability, one has a 1,000 liability per month.
Yes, and as per instruction, Lordship, she is also taking tuition. So
could be. Therefore, for the other also we have kept it at 1,500.
Already the issue here is that, my lord, even though it is unofficial, 1 minute, 1 second, my lord.
Okay, do it like this. 1,500 for the male child and 2,000 for the female child. Full stop. It is made clear that this interim is being given only during the pendency of the criminal petition, and the criminal and the learned trial court shall not be influenced by the quantum fixed by this court while disposing of the matter in accordance with law.
yes, Lordship.
Criminal petition, criminal revision petition accordingly disposed of.
Obliged.
They are your children. Don't argue on what is the tuition fee and what is not.
Here is that she was not.
No. Even submissions on that line should be avoided. Had the children been at home,
No, my.
would you have argued? Not a word.
Yes, my lord, I requested my wife
To?
to reside with me. Now she left me, it is their problem, my lord.
Those are problems beyond the law.
My lord, deeply obliged, my lord, deeply obliged.
Yes. Yes, Mr. Goswami.
Lordship, the petitioner was arrested on 1/7/25.
1/7/25. Yes.
He was produced on 1/7/25, and the order was, I have flag mark, Lordship. Pink color flag, horizontal, Lordship. On 47 notice, I am submitting, Lordship, regarding the 47 notice.
Which one? This one?
Yeah, top bottom. 1/7/25 order. Heard the IO and peruse the notices under section 47 and 48 being given by the IO. And being asked, the accused person has stated that he and his family members, relatives have been properly informed by police regarding the grounds of his arrest and the brief of the instant case. My submission is that, Lordship, the purpose of serving notice of 47 and 48 is clearly fulfilled on being asked by the accused by the Honorable Trial Court, Lordship.
Are those 47 and 48 notices on record?
Yes, 47. They have put.
I have showed you. 47, 48, 30.
Only they have submitted, another senior submitted there only because of language. His signature was in Bengali and grounds of arrest and other things are written in English. They have not made any submission before that trial court on this regard.
You was in an injured condition, but the report is there that.
What
the
kind of
police
injury?
Assaulted him. That it is your good. This is the judgment of Bian Kumar. I have given red mark. That line. Then another Supreme Court, Mihir Rajesh, my lord. He is in his own language. Then my third one is on the 36, my lord. Our own coordinated bench.
Implicated করনি।
How do, doesn't appear in the language.
On
He has raised it.
her
It is not
question.
because we want to because he has raised an issue. I have to answer that. How do I
Yes.
say that he understood the language? The order of the magistrate also doesn't reflect.
But only my humble submission before Lordship, the purpose of serving notice 47 and 48, he has not deprived of his, he has to avail his rights for liberty, Lordship. But he has already fulfilled the conditions, Lordship. When he was asked by the magistrate, he was fully informed. Yes, I have fully
Why
informed.
should we disbelieve the magistrate then? Magistrate has said that I have asked him and he has said he understood.
Yes, he
It is a
understood.
prototype answer will not do.
Huh?
It is a prototype question by the
Oh,
learned
can we say that about a magistrate's court?
No, but what I am questioning, the learned magistrate ought to know this provision of the law, whether it has been served. And the Mallard, you also know the importance of 47, 48 and 36. Very, very fundamental rights they are saying. And 36, Mallard, blank. 36, what state? It must be attested by the accused and an independent person of the family. Where it is that?
What do you say about that?
36. Or
36.
Judgment I have placed, Mallard. What I have placed another judgment, 36.
There are two views in respect of 36 Lordship. One view, Lordship, they have placed and another view is taken by another court, Lordship, our court judgments, where they have stated that if 47, 48 is complied, 37 need not be complied.
When we have a doubt on 47 and 48 regarding the language itself.
Lordship.
So therefore 47 and 48 to be complied.
Yes.
Have been complied is difficult to hold. We would have tilted in favor of holding it to be compliance. Somewhere one sentence or somewhere the 48, the lady has signed in English, where she has been told that he has been caught with some drugs, but it does not contain the details. But yet, he has been caught with the drugs and he has admitted some knowledge of what might be going on. But otherwise in 47, he signs in very broken handwriting his name. English may not be the proper language to have served upon him. Coupled with that fact, if the 36 is not complete.
So my submission will be 36 is totally different.
Once 47, 48 done is done.
Done.
If a coordinate bench has taken a view that if 47, 48 complies, 36 is not necessary, then it would mean that there is a connection. Then you would not be in a position to argue that they are separate.
Maybe, Lordship,
that evaluation had to be taken together.
Lordship, I may not have been proper in submitting, Lordship. The coordinate bench has stated that 36 is not necessary. That is a separate section. 47, 48 is essential. In that particular case, 47, 48 was complied with, and therefore, Lordship, 36 was not taken into consideration and going by the submission made by the prosecution. In the instant case, Lordship, there are two aspects. Lordship, one, he was specifically asked, he stated that he is well aware of his arrest and all the grounds. His family members are also aware. And secondly, Lordship, he did not raise this ground there. So, Lordship, should there
that not raising the ground there, in fact, if we go by the usual criminal law that we understand, would be to his advantage. He was not in a position to do it.
That's okay,
because he did not understand.
Lordship. But Lordship, regarding that observation by the concerned court, a question was put to him, Lordship. He has stated that it is complied with. So, Lordship, there must be something on record to indicate otherwise, Lordship.
What do you understand the implication?
No, the Supreme Court in Mihir Rajesha says, once the question is raised, it is on the arresting authority to show.
Yes.
Once the question is raised.
Yes.
It is upon the arresting authority to show, not upon to him. If I have understood correctly, I do not know.
But Lordship, that is in regards to if there is no compliance of 47, 48 and that question is raised. Now here, Lordship, it has been raised, but there is compliance. Only the language is...
That is the main thing, brother.
Now, Lordship, please stop interrupting me. I'm not your brother and don't call me brother.
You are my definitely brother. Why not?
No. We have a counsel here. I'm not your brother. Now, Lordship, will kindly see here, NDPS item, only question is, Lordship, regarding NDPS item which has been recovered from him. He was arrested, he was given the grounds in 48.
Now, Lordship, there, the code below, Lordship, taking all precautions.
And what about that memo of, where is that memo of arrest?
36, Lordship, in that respect, Lordship, section 5 of the BNSS also states, Lordship, that the special statute will override the CRPC or the BNSS. The NDPS is a special statute, Lordship. CRPC is a general statute. It will always override the general statute, Lordship. And Lordship, regarding 36 also, Lordship will kindly see the requirement of section 36. It comes from DK Basu case. When the DK Basu case was given, Lordship.
No, the time when the arrest is made, it is but settled law that some respectable person, someone
Yes.
other than the arresting authority has to sign it.
Yes.
Who has signed it?
Nobody has signed.
Then
Lordship, for that.
How do we believe the arrest properly done?
Lordship, for that purpose only, Lordship, I am submitting. If Lordship kindly goes to the DK Basu case, why it was incorporated. Lordship will have to see the purpose behind 36. Only because, Lordship, the information needs to be given to a respectable person or a family member so that he is not met with custodial torture or anything like that.
Injuries, as per medical report. We arrested an injured person is not on the record.
Yes.
So injuries after the arrest.
In that case, Lordship, DK Basu, if there is non-compliance or custodial torture or anything, Lordship, that compensation amount is also there and disciplinary proceeding can also be taken.
And the man remains in illegal custody.
Nothing is
nothing is shown. So we'll
in DK Basu case there is no indication of that fact. And NDPS Act was not in existence in the time of.
Therefore, we will not refer to NDPS to DK Basu so far as 36 is concerned in this particular case. When the arrest memo doesn't have has not complied with anything.
Yes.
It is a blank piece of, it's a piece of paper signed by the person. In fact, where is the signature of that man? Is there a second page to this?
No. If lot.
This is the only page. Even the arresting authority signature is not there. You can have a copy of this. This is not the kind of arrest we can uphold.
If
The custody, if you want to be him to be in custody, Mihir Rajesh Sir provides. Second arrest properly done. Fine.
Yes.
Why not?
If Lordship is otherwise convinced about 47 or 48, then Lordship will not.
47 without the language that he has asserted that he understands English or it has been explained to him in English. Magistrate not saying that it has been made known to him in a language he understands without putting to fault anybody, either the arresting authority or the concerned remand court. We are not putting fault to anybody. His assertion that I did not understand what had happened goes unrebutted. Coupled with the fact that 36 is not signed by anybody and contains a remark that he has injuries on his body.
Two things, Lordship, again. 47, Lordship, there is a specific order, Lordship, that he has been asked whether he has been informed, whether his family members are informed. He has stated in the affirmative. Lordship, need the trial court again ask specifically, Lordship, that whether it has been explained in your local language and anything, Lordship. There is no such direction, Lordship. Compliance, the trial court rightly has stated, Lordship, whether it has been complied or not. The purpose has been shown, fulfilled, Lordship, in my respectful submission. But otherwise, Lordship can take a view, Lordship. I have no issues with that, Lordship. But to distrust the trial court, Lordship, that the trial court has not elaborately asked him whether it has been explained in the language.
When it is not that we are trying to set down the law for every case to come. He has raised an issue, we need to answer that.
Yes. In light of the observation, Lordship. Otherwise, we'll have to rely on something, Lordship.
Therefore, this court is not proceeding only on the basis that he should have asked this and he should have asked that. No, we are not proceeding on that.
Yes.
Absence of it, coupled with. If you understand what we are driving at.
Absence of, I'm sorry, absence of.
The absence of that assertion that it was explained to him in a language that he understood, the ground of arrest, he understood in his own language. There is no assertion anywhere in any of the documents. that factor coupled with the fact that the arrest memo was not signed by as required in law, would it lead to a
Lordship, I'm
illegal arrest?
Lordship, that 36, I'm respectfully, Lordship, putting it aside, but 47, Lordship.
Alone 47 and 48 would not have been a ground in this case. Therefore, respectfully, we are also saying that you cannot push away 36 in this case. Had this 36 been complied totally, we would have said that substantial compliance 47, 48, we go by that. 36 is complete.
Lordship,
All the grounds gone.
Lordship, the object of 36, I'm extremely sorry, Lordship, 36 is not connected with 47 and 48. That is my submission.
True, but with an arrest, it is connected.
With an arrest.
So when that arrest on 36 goes,
Yes. Lordship,
what it means?
let them show one judgment, Lordship, where it is stated that only non-compliance of 36 will.
Yes, I have
proceed
placed,
trial.
brother.
Lordship, there is one more
There is
judgment.
another judgment also quoted, brother. My Lord Justice straight here.
Another coordinate bench has stated, Lordship, that 36.
Get it settled.
Yes, Lordship.
Get it settled. But till such time, what about Article 21 and 22? What do we do with that?
Yes.
Would it be at his risk?
No. That will
Can it be at his risk?
That would not be fair, Lordship.
That would not be.
That would
We
not be
have a legal argument before us.
Yes, that would
But
not be fair. But,
a
Lordship,
man's personal liberty,
Lordship,
when a re-arrest or when a fresh arrest is not barred by law,
then Lordship respectfully may not take a view on 36, Lordship, because then I also need to have the opportunity to satisfy Lordship on 36. If Lordship is taking
in
that view.
cases of writ petition, Mr. Sharma, we can be so wide in giving you time.
Lordship.
In case of personal liberty, how much time?
Tomorrow, Lordship.
Tomorrow we can do. Tomorrow, sir.
Only beginning. Objection.
Because he's saying 36, there is a dissenting view.
Yeah.
So if it's a dissenting view,
Against that judgment, they could have preferred appeal in the Supreme Court. They have not done it. It remains. And this is not the lone judgment. I have got other copies also. Other coordinate bench.
have all the judgments tomorrow.
Yes, I have got no.
Then if we are not convinced with a certain view, we can put them both in two different, what do you
Yes,
call that? Balance scales and try to see which has more weight.
Two views are there, Lordship. Two views are there.
Two views, we'll try to see which of the views fit best in this case. That is the best we can do.
Or Lordship can settle the issue if Lordship is convinced about 36. Then
I would, if we find that these two views both would be applicable and both are totally dissenting, it would not be upon a third coordinate bench to say that yes, this view is correct. It would be upon a state division bench to say, is it not?
Yes.
But if we find that these two particular views were on different aspects, and this aspect or that aspect fits into in this case, and therefore we can follow this, then it becomes a different issue. Therefore, we'd like to know which judgment are you relying on. In this case, which was placed before us, you can have this this bail application number 3712 of 2025. Here, 47 was.
Lordship, may I know the author of the judgment, Lordship?
By Justice Kalita.
Yes, I was the one, Lordship, conducting it.
No.
I'm
Mr. P. Bothakur.
Oh, P. Bothakur.
And applicants refer to DK Basu.
Yes. But
Rigors of 37 was argued. I'll just give you a gist of what happened.
Lordship, I have perused.
Then somewhere I saw 47.
What I am submitting is, Lordship, respectfully, Lordship, to decide the issue of 36 as a separate issue, not with consonance with 47 and 50.
No, then we go straight by this. This court has held that 36 should have been followed.
No, Lordship, there is separate view, Lordship. That's what.
And that is what. So tomorrow have those judgments. We may have the time to take our view.
Lordship.
Time permitting.
That what I was
Tomorrow,
insisting
at the
on
request
that
of the learned APP, list the matter tomorrow.
Kalita, he will extra.
Tomorrow it will come.
TD not received.
I'm keeping the certified copies you had given me on with my file. Or you can take it back.
My lord, but I pray the period 37 also can be 37. Nobody is giving an importance. It is a statute.
We'll do it tomorrow, sir.
37 also.
Tomorrow.
37, my lord. I had an idea to submit my. Actually,
Yes.
I'm taking that designated police officer. That is the new thing of this year, the new businesses. Why it is been? There is a reason. Why earlier things were not there in the CRPC? Why in business? What it said that state government shall
Designate.
designate. And it is given. Some government has given a go by. Still today it has not been done. Why? Then what is the use of this statute? Many states it has been complied with. That is to also give a look. Well, unless your lordship give a direction, they will not do anything. Government will not do anything. That's why Supreme Court judgment, copies are sending to all chief secretaries. Follow. Like D.K. Bosu's case. Now it has become a.
We will differ with you on that because Supreme Court judgments are also sent to all the judges, and
Yes,
we have never violated the orders of the
Definitely.
Supreme Court. We
The violation.
even before it reaches us, our attempt is to. Therefore, just because they are violating it is sent to them would not be a correct statement.
Correct. Very true.
It is for knowledge.
Yes. And moreover, why it has been sent to all the registrar and the chief secretary? Because that is the new things that Supreme Court is giving new laws that has to follow.
But had it been in the days of the postal stamp,
Very true. That is
it
also
would it would not be so quick.
Right.
Now an email is less expensive,
Very
quicker. This one you don't have the CD. Item 40.
40.
40.
40, Lordship, CD was called for, has not been received, Lordship.
He is without an interim.
Yes, sir. Lordship, next week, any day, Monday?
Huh?
Monday.
This was that IMFL.
Yes, IMFL. Lordship.
Why are you absconding?
Lordship, my senior will submitting on the next.
When?
The next day fixed on. Lordship.
Monday, Lordship, may call for the case there is.
Huh? $35.3 is also not there. You have not said here how you came to what could be an appropriate explanation for 120 liters into catering to 500 people. When? Sir, when do you?
Monday, Lordship.
Monday. The CD is awaited. List again on 23rd of February.
Item 50.
This lordship.
Mm.
I pray for 2 weeks time to take steps, lordship. I see. I see.
The learned counsel appearing for the petitioner, for the appellant has submitted that 2 weeks further time would be required to take steps on the respondent list on 31st of March 2026, allowing the petitioners to take, the appellants to take steps by speed post on or before 27th of February 2026. Do it before 27th or we close it. It's against acquittal.
Yes, yes.
Then we'll close it if you're not interested. You just can't keep a sword hanging on someone.
51. 51.
None appears for the petitioner, for the appellant on call. Full stop. Steps were required to be taken by the order dated 19/12/2025. Steps were taken on 23/12. No. Steps were service report on the steps have not been received. List again on the 1st of April 2026 with service report.
Made to the Lordship. Lordship, this is a revision against concurrent judgments of in an NI Act. Madam, what has happened was there was a check of 75,000 that was issued. The trial court had convicted on 11/10/2012 with a compensation amount of 1 lakh rupees. The appeal was filed before the district judge Nagaon, which was dismissed on 31/10/14. Once the revision was filed, my lord, the stay was granted. Now, if your lordship takes up order dated 29/1/2016, I have put a flag mark there, violet color flag mark. My lord, this order says of compromise, but nothing, no document is on record. I have checked the file.
Learned counsel, the petitioner submits.
I'm an amicus.
Huh?
I'm an amicus.
Oh, you are an amicus. Yes.
This documents, this order speaks about a compromise, but there's nothing on record. I've checked the file. Subsequent to this order, nobody has appeared in the case.
It is against.
The revision is against judgment on order dated 31/10/14 passed by additional session judge Nagaon.
We'll dismiss it for non-prosecution. What to do?
I leave it up to you.
Some check bouncing case, sentence of 1 lakh. 2016 compromise was going on as per the petitioner. None appeared. We appointed an amicus curiae. Today none appears. Non-prosecution. But Mr.
DK Bhattacharya.
DK Bhattacharya, amicus curiae is appointed by this court. The learned amicus submits that the operation of the impugned order impugned in this criminal revision petition had been suspended by the order dated 2/3/2015. Thereafter, for the order dated 29/1/2016, it was submitted that a compromise petition has been filed by both the parties. Full stop. The learned amicus curiae has submitted that going through the records, no such compromise petition could be traced out. Full stop. None has appeared for the petitioner on and from 15/12/2025. Full stop. This criminal revision petition is therefore closed as not being prosecuted.
Trial court records may be sent.
The trial court records be sent back.
Right.
Court appreciates the